May I please, Lordship?
Yes.
Lordship, admission matter, item number 12. My Lord, I pray to fix the matter at 2 p.m., my Lord, due to my personal inconvenience.
Item?
At item 12, admission matter,
Yeah, why?
at 2 p.m., my Lord.
All right.
Lordship, obliged.
Yeah, please, Lord. Lordship, I have a prayer regarding item number 52, my lord.
52.
Yes.
Yes.
As case there was call for, probably it has not been received, my lord. Yeah, 52. Is there not received?
Not received. Interim is there.
Interim is there, my lord.
List again on. Interim order. Interim order. Asked earlier to continue.
Obliged, my lord.
Please, Your Lordship, I beg to mention item number 58, my lord. Maybe taken on 3rd,
Huh?
maybe taken on next week, 3rd of December.
Heard of? All right. 3rd of December.
May I please, Your Lordship? I beg to mention item number 73 and 74, Lordship, supplementary list.
Yes.
Yes, Lordship. Kindly adjourn for 2 days, Lordship. Next week may be fixed, any date may be. Obliged.
May I plead your Lordship? Lordship, item number 3 may be taken up on 2/12, your Lordship, with BA number 3689, your Lordship. FIR is same, your Lordship.
Item number?
3.
List on 2nd of December along with.
With BA number 3689, your Lordship.
Item number one.
Obliged, your
Yes.
I beg to mention item number 57, my lord. Today it was for scan copy of the diary, my lord. It has not come, my lord. It may be fixed, my lord. Interim order may be continued. my
One
lord.
copy of TCR not received. List again on. Interim order is there.
Yes, yes, my lord. No, by
Continue to the next date of.
Definitely. Interim order shall continue, my lord.
Yes.
Obliged, my lord.
Please, your lord. I beg to mention item number 66. It's the criminal appeal, my lord. My lord, the convict had already been released from the jail on completion of the term, my lord. My lord, they just don't want to press the appeal, my lord.
66.
Yes, your lordship.
It is with. What about the other one?
Other one, same, my lord. Other one. I have not-
67?
Same time was there, my lord. That's why maybe both are released, my lord. Because I am not,
Maybe. What do you mean maybe? Are you appearing in the second case?
second case, I am not representing him, my lord. Amicus has been appointed, my lord.
We'll see. Let the matter come up.
My lord, in this matter, my lord. 66.
No,
my
because it is with. If we adjourn this one, that also gets.
lord, actually, both are convicted for 4 years. Term has completed, so both are released, my lord. I have a document, my lord, release letter, my lord.
Right, 66 you write. Is submitted by learned counsel, Mr. M. Soikia,
Yes, your lord.
that the appellant has already completed his sentence and has been released from jail. The release copy of the release certificate dated 30/06/25 has also been submitted. Hence, the appeal has become infructuous and is accordingly closed. The 7 we don't know right now.
My lord, LCM send back, my lord.
Send back the. That will be the same LCR, I think.
Yes, your lordship, same.
So at 67, we'll see 67 to reconciliation silo. Yes, any other mention?
May I please, Lord, sir, I beg to mention item number 60, my lord, 60.
Yes.
Can this matter be taken some other day, my lord? After vacation, my
The
lord,
prayer of learned counsel for the petitioner lists the matter again on.
after vacation.
Kindly ask one of the public prosecutors to check if the same sentence is there. 67,
Yes, we'll have to go through, my lord.
that is the record. Go through if it is the same sentence. If it is same sentence, then he must also have
January delay. 60. There is an interim order, my lord.
interim order to continue.
Obliged, my lord. Keep your-
Yes, follow up.
May I please, your lordship? My lord, 483 application, my lord. FIR at page 9, my lord. For 30 days as on today, my lord. FIR at page 9. The allegation is that, my lord, I am an employee of a shopping mall, my lord, Reliance Trends shopping mall at Borpata Road, my lord. And allegation against me that I planted a mobile phone on recording mode, my lord, in a trial room of women ward, my lord. And then the informant entered into the trial room for changing her dress, and then some pictures were captured, my lord. This is the allegation. But my lord, actually I am the employee of that shopping mall, my lord, and I was arranging the clothes, my lord, in the trial room which were abandoned by the customers, my lord. And then my mobile phone were kept in the AC cover, over the AC cover, my lord, for a few while, my lord. And then this lady entered into the trial room. Immediately I removed the mobile phone, my lord. Then this informant saw that I was removing the mobile. Then she suspect that I was recording the videos, my lord. And then she make hue and cry, and some person gathered there, my lord. My lord, kindly see the sections, my lord. Sections 74, my lord. Section 74 is assault or use of criminal force to women with intent to outrage her modesty. Earlier it was 354, my lord. This is non-bailable sections, my lord. And thereafter, my lord, section 77. Earlier it was
will have to see.
354C of IPC, my lord. And all the sections are bailable, my lord.
The only place you found to keep your mobile is in the ladies' changing room. Yes.
However, my lord, these sections are bailable, my lord. So far, criminal force and assault part is there. That is non-bailable, my lord. The voyeurism, stalking,
512.
obliged. My lord, may I please, your lordship? My lord, this is a search-sheeted case, my lord. And after framing of search, one number of witness has been examined, my lord. The case is in trial stage, my lord. So at this stage, my lord, a record may be called for, my lord.
Scan copy of TCR along with CD.
Obliged, my lord.
I've told only of delegated. After 812.
Your lordship. My lord, but in this case, my lord, the petitioner was arrested, my lord, on 9/10/2025, my lord. And my lord, probably, my lord, the CD is available, my lord, because in item number 60, my lord, the same FIR, my lord, the already accused, my lord, she has already approached this on code and anticipatory bail has been granted to her, my lord. And my lord, probably CD is available, so lordship may take up this matter, my lord.
Along with 60.
My lord, yes, 60, my lord.
60 has been adjourned, my lord.
Adjourned, my lord, actually. This has been adjourned in the month of January. It is fixed, my lord. I am already in custody from last
CD is here.
50 days, my
Yeah,
lord.
my lord. In connection with item number 60 case, there is that this is the motion item, man.
Already 50 days in custody,
My
my
lord,
lord.
before the bail hearing, my lord.
Yes.
Yes, ma'am. Obliged, ma'am.
And in this case, my lord, petitioner is behind the bar, my lord, with effect from 27/7/25. 125, my lord. It is a forgery case, my lord. Page 13, my lord. Collected money in the name of IPO, my lord. The informant is executive officer in the, my lord, he imagined that it will be enhanced, my lord. He has invested initially. Subsequently, my lord, he, informant is the, himself is the executive officer, my lord. And in so case, he has been arrested, my lord. FIR, my lord, page 13, my lord. 7,50,000, he has been, my lord, invested there. And so far, my lord, shown case arrest memo is, my lord, page 17, my lord. And except 3, my lord.
Charge-sheeted.
Not solicited, my lord. He is in jail, my lord.
Since
Since 17, my lord, 27/7/25, 125 days.
how is
Aspect-
it possible?
Yes, my lord, 338, my lord, and 318. In shown case, my lord, in original case, he has been granted bail. Bail order is also there.
Phone case, since when?
10/10/25.
10/10.
Then it is shown. Same offense, my lord. Kindly peruse your lordship, page 17 first. The accused Shivam Pandey, who is presently in judicial custody in sub jail, Haflong, in connection with GR case number under section 318, 336, 338, is physically produced. Roshan Thapa of Haflong PS is on being the accused person stated that he has no injury and so illness. Considering the middle next page, nature of gravity of offense, IO prayer for son arrest of the accused person is allowed. Remand the accused to jail hazard. And bail reject order, my lord, I have annexed here. Next page.
How
Annex
can you
sub
say
four.
it is the same case?
Yes, lordship.
How can you say it is the same case?
Sir, my lord, allegation, my lord, three earlier case, my lord, bail
Must have
order.
been a different affair by different person.
Different. Affair different. But allegation is same. Most.
If you commit different offences at different places, it will give rise
Yes,
to
yes, sir.
different cause of action.
Section is, my lord, 318 and
All right,
338.
let us have the CD then.
Already, my lord, 125 days, my lord.
Yes.
We are on 5th, my lord.
Amount is, in the earlier case, is 7.5 lakhs. In this case, how much?
Fifth of December, my lord, CD.
May it be pleases you lordship, I'm representing as legal aid counsel here, your lordship. Here, your lordship, applicant, your lordship, applicant was, your lordship, charged as, your lordship, under section 103 of 1 BNS, that is amounting to murder, your lordship, attempt to murder. But here, your lordship, 2 FIR has been stated, your lordship, 23/11/2024, your lordship, that is, FIR registered against the, against the petitioner, your lordship, on at about 8 p.m., your lordship. I would like to take you for a moment, your lordship. Annexure 1, A, page 19, your lordship, dated 23/11/2024. That was, your lordship, brother of the informant, your lordship, informant brother was murdered, your lordship. So, your lordship, informant has given one filed FIR, your lordship, registered under section 103(1) BNS, that is on 23/11/2024. Her name is Tultul Puri, your lordship, and she alleged that Navasmita Sarkar, who is the present petitioner, your lordship, and your lordship, beforehand, your lordship, she stated that my brother Shri Anupam Sutradhar, at the time accused person, took a sum of rupees 2 lakhs. That is very much annexure 1, page 17 of this petition, your lordship. I would like to take you page 17 of typed copy. I'd like to read it, Your Lordship. And she curtailed her relationship with him. Consequently, both the parties lodged two cases, PS case 201/23 and CRC number 216/23, which is still pending. Yesterday, as per English calendar, on dated 22/11/2024, at night approximately 7 p.m., my brother came out from the house. Subsequently, we came to know that dead body of my brother was lying on accused house. Today, as per English calendar, on dated 23/11/2024, at morning 1 a.m., we went to accused house and had seen dead body of my brother. My brother neck was cut more than half and cut marks had seen over his face and on his thumb finger was next page, Your Lordship, page 18, cut apart, and it was somewhere else, not attached with his finger. Moreover, we have seen the dead bodies, another 3 family members. I would like to press it here, Your Lordship. Dead bodies of 3 another family members of the accused, that is Nabasmita Sarkar, father, mother, and sister, younger sister, was brutally killed. And she was not present also, Your Lordship. She is a that teacher, Your Lordship, staying along with another brother, Your Lordship, at ITI Nagaon, Your Lordship. Her brother was studying in ITI college, Your Lordship. So here, Your Lordship, the police has to escort her and came back to the incident, Your Lordship. And since her mother, father, and younger sister is also no more, Your Lordship. So her brother, remaining brother, and the petitioner, Nabasmita Sarkar, was escorted by the police, and they were taken back to this place of occurrence of the mother, Your Lordship. And beforehand, Your Lordship, the informant has given this FIR, Your Lordship. I would like to take you to page 22 of Annexure 2. Here, Your Lordship, earlier, before Your Lordship, that the brother of Nabasmita Sarkar has already, Your Lordship, registered one FIR that is on dated 23/11/2024, and FIR number beforehand 405/2024. Your Lordship, already he has also stated that I have annexed it, Your Lordship, in 2A. That is on page 23. Type copy is still there, Your Lordship, in the petition. I'd like to take you to page 23.
So 4 people were killed in the same house.
Same house, Your Lordship. And that lady is also not here, Your Lordship. She is a TET teacher, and probably she is
Yes,
staying.
PP.
And Your Lordship, I would like to take you to this FIR, Your Lordship. Beforehand, informant given this registered, and beforehand that petitioner younger brother has already given, Your Lordship. Your Lordship, page 23. I would like to read
I've
it.
seen that.
With utmost honor, I beg to state that I am the resident of the above noted address, that on 22/11/2024 at about 10:15 p.m., I got to know that my father, Gunadhar Sarkar, my mother, Suradhani Sarkar, and my elder sister, Jayasmita Sarkar, were brutally murdered in my own house at about 8 p.m. And an unidentified person was also murdered in my house, who was
Yes, we have seen that.
later. And the
Page
most for your
41, Annexure 7 or trial court order, Lordship.
Annexure?
Rejection order.
Page?
Page 41, Annexure 7, Lordship.
It was stated that, but Your Lordship, enough sufficient records is available in this petition, and already in that, Your Lordship, trial court, Your
So
Lordship.
after presence of the
Your Lordship, I am praying, Your Lordship, just here in
Records.
interim, because
PRS bail is
here, Your Lordship, payment has already been given, Your Lordship. She has stated false allegations, and Annexure 4 is available, page 32. GP payment is already annexed here, Your Lordship. And moreover, Your Lordship, when they are in love relationship, Your Lordship, the petitioner has already registered one case against him because he has been troubling her, Your Lordship. Your Lordship, page Annexure 3, page 26, type copy. This petitioner has already lodged one FIR against that Anupam Sutradhar, informant brother, Your Lordship. Your Lordship, I would like to read it here. And moreover, Your Lordship, I would like to press one your lordship statement here. Most respectfully, begs to state that I am the permanent resident of above mentioned address and the teacher of Kosolukwa Islampati Primary School. From 2 years back, I have a love affair with below mentioned accused number 1. After getting my job, the accused number 1 has taken money and also looted a huge amount of money from me. And also on roads and its street in front of other people, he used
You
abuse.
see, the problem is that the Sessions Court has, after perusal of the case diary, has said that there are materials against you. So in these circumstances,
there-
we have to see the CD.
Lordship, I am praying interim prayer, your lordship. Interim may be granted, your
Case
lordship.
for interim is made out because all on perusal of CD.
FIR registered on 23/11/2024 and she has approached before trial court 23/4/2025 and
Already,
they are
your lordship,
rejected.
there are sufficient, your lordship, records are available, your lordship.
After praise of the case, the lordship will consider.
Short date may be given, your
Yes,
lordship.
give us short date.
At 12.
Human? 13. 19 December. That is the very last day of court, your lordship. Beforehand, your lordship. 14.
15.
14.
14 holidays.
Oh, holiday.
Uh,
15 then, your lordship. I'm deeply obliged. Your lordship, I have made a party informant also. We need to take a step. So,
In this case, why informant is
yes,
necessary?
your lordship. Deeply obliged.
May I please, Lordship?
Yes.
Lordship, this an FIR was registered under section 304B, 109 and 34 of IPC. But later on, Lordship, the investigating officer, he submitted a final report, Lordship. But later on, the informant gave a protest petition against that final report, for which a complaint case has been registered against the present petitioners, and they have received summon for their appearance in the learned court below, Lordship. For that, this present application, Lordship. Since the section involved here is a session tribal section, Lordship, so there is apprehension of arrest of the present petitioners, for which the present application.
Third learned counsel for the petitioner and third learned additional PP. This is an application under so and so. Harshit, in this case, the IO had submitted FR, but pursuant to a test petition, the learned magistrate. Where is the order?
Lordship,
Where is the order of the magistrate?
order follows from page 29, Lordship.
Learned magistrate, by order dated 11/10/23 forwarded the protest petition to the learned CJM Kamrup Metro for registering it as a complaint case, pursuant to which it was registered as a complaint case and summons has been issued to the petitioner. Your name is?
S. Yasmin.
Who is Robin Hussain?
Sorry,
His name is
Robin
Saddam Ali and-
Hussain is the husband of the victim, and for whom this application is filed, it is Ismail Mandal and Saddam Ali. Ismail Mandal is the father-in-law of the victim and Saddam Ali is the brother-in-law of the victim.
The allegation in the instant case. Para 4. Okay. Call for the scanned copy of the TCR. Having regard to the fact that the IO had submitted FR in the case, and also the fact that co-accused public husband of the victim has already been granted bail by order dated 1/02/2020. By the learned additional session judge, Kamrup Metro. It is provided that in the end, upon the appearance of the petitioners pursuant to the summons released on bail of ₹20 like amount. Satisfaction of the learned stroke arresting authority. Based on
At your pleasure.
May it please your lordship. My lord, this is 482 application, my lord, and the allegation are under section 137 subclause 2 and section 142, lordship. And your lordship will find the FIR from page number 7 onwards, my lord. The allegation is that, lordship, 121/9/2025, lordship, the minor daughter of the informant was kidnapped at about 10 a.m. My lord, the face of the FIR, it shows that, lordship, FIR has been registered on 26, but police record reflects that for the first time information given to the police at 6 p.m. 127. My lord, it clearly shows that if a minor daughter was kidnapped 121 and FIR is filed 127, it itself delay. Lordship, my submission is that the FIR is concocted and manipulated, my lord. A case diary may be called for at this stage.
yes,
Only
CD.
CD and victim statement, lordship, on 18/12.
Oblige, your lordship.
May it please your lordship. My lord, the petitioner before lordship, he is an assistant manager in the insurance company. Now, my lord, on 13/9/25, there was a Lok Adalat, my lord. And as many as 32 claim cases under the Motor Vehicles Act were recommended for settlement. Before I read the FIR, I am giving the background, my lord. Now, it so happened that out of the 38 claims which were placed before the Lok Adalat for settlement, one of the claimant did not turn up. So there were effectively 31 claims. Now, in respect of the 31st claim, the advocate for the claimant maintained that claimant is coming. Therefore, this case also should be taken up for consideration. Thereafter, my lord, in the individual information sheet, the branch manager as well as the petitioner, they both put their signature in the approval note. But it so turned out that in spite of the assurance of the advocate for the claimant, that particular claimant did not turn up. So, my lord, the case in the absence of the claimant, it cannot be decided. Therefore, my lord, nothing was done. No money was paid on account of that claim. Now, my lord, this branch manager, to save his skin, now he has filed an FIR saying that somebody has forged my signature in the approval note, and I suspect the assistant manager, that is the petitioner before lordship, who must have done it. Milord, he has also signed in 31. I have also signed in 31. Please come to the FIR, Milord. That is the case.
Page 17.
Page 17. On 18/9/25, Milord. Sir, with due respect, I would like to state that I am working as in charge TB Hub, United India Insurance Company, Guwahati Regional Office. And yesterday it was brought to my notice that somebody has forged my signature in the claims approval note in settling National Lok Adalat at MACT Kamrup on 13/9/25. I have sufficient ground to suspect that Abhishek Bhattacharya working in the same department has hand in the particular matter. So kindly investigate the aforesaid matter as it is involved officially, for which act of yours I shall be grateful. My lord, his suspicion is good enough.
Which approval note?
And my lord, there were 31 approval note. Which particular approval note? My lord, no monetary losses caused to anybody. In the absence of the claimant, both the 31st and 32, both these claims were not, my lord, recommended for settlement. So this is the case, my lord. I am, my lord.
Interestingly, I think we had the matter relating to the same FIR yesterday or a couple of days back.
Ah.
I think it was argued by Mr. Mahajan
I think
and-
lordship has granted bail, my lord.
and he was blaming you.
Okay. No, naturally, my lord, somebody will try to do that. My lord, my humble submission is, my lord, end of the day, that signature is there. So if that is, my lord, my fault, it will. First of all, kindly protect me in the meantime. Let them call for the CD, my lord.
I pray for case there.
Had it been a case where the money was paid, things would have been different.
Heard Mr. K. N. Chaudhary, Learned Senior Counsel, Learned PP. An application under so and the allegations as per the FIR is that there are 4 of them. Call for the CD. N. Chaudhary, Learned Senior Counsel submits that present petitioner, who is working as
Assistant manager.
United India Insurance Company, as well as the branch manager, both signed the form
Approval note.
approval note in connection with the alert. But since the client did not,
Claimant.
payment did not turn up, branch manager has lodged the instant FIR in order to save his own skin. Further submitted whether the signature of the branch manager is genuine or forged can be determined only after forensic examination, and said document is already in custody of the police.
Please.
Having I did that in the released on interim bail of ₹50 security of like amount, satisfaction of the arresting authority in connection with the aforesaid case. Further provided that the petitioner shall appear before the IO within a period of 7 days from today, cooperate with the investigation. Again on
January 8th.
Deep level.
Item number, my lord, wherein here.
not completed.
Let him, my lord, clarify, my lord, how he has calculated, my lord. I'm not opposing also, my
No,
lord.
no,
but
he's given a release order, release certificate.
The
but my lord, from the date of conviction, my lord, I have calculated even the investigation also, my lord. During investigation trial, they will be.
No, how will he benefit? He wants to withdraw the appeal that it is over.
The release order has been furnished, then I have nothing to submit, my lord.
It has
But
been
both the
submitted.
accused has been convicted on the same day, arrested same day, my lord.
Yes.
And one person both bail after 10 days, my lord.
Oh.
One person, my lord, he remained for 90 days, that is 3 months, my lord. Another person, he remained, my lord, for 100 days during investigation.
So the calculation may be different in the both the cases.
The release order has been, my lord.
The release order is in only in respect of one.
One accused.
So what about the other? That is what I wanted to say. Item 66 is release order is in relation to item 66. What about 67? That is the question. He was submitting that it applies to both, since both were sentenced to the same quantum.
I have calculated, my lord, there are 4 months left, my lord.
So let counsel for the in 67 come and clarify what is happening. Call up 67.
May I please, your lordship? Lordship, it's an anticipated bail, lordship. This is Chandwari PS case, lordship, registered under 1031. So CD may be called for.
Yes, CD.
Yes, lordship.
1812.
Please, lord.
My please, Lordship. Lordship, FIR on page 14, my lord, registered under section 103, my lord. Lordship, may I call for CD, my lord, and PM report, my lord. Yes.
CD and PM report. Yes.
1712.
Publish, my lord.
Please, your lordship. Kindly pass over the matter for the time being.
Why is it listed?
My senior is on late.
We have
Yes,
too
yes.
many matters to for time being listed in the next week.
Please, lordship. Lordship, I received the affidavit today morning only, also. Lordship, we fix it on 3rd.
Then counsel for petitioner submits that the affidavit has been received today only. Please the matter. Give a date.
On 3rd of December. Third. How like?
Coming item number 4.
In this matters, I have received some vital facts, Lordship. I am filing an additional affidavit to bring it on record. Lordship, may fix it on next week.
Let counsel petitioner press for time to file an additional affidavit.
14 to
Prayer is allowed, list the matter again on
14 to 16. No. Okay. 14 to 16. April. In this matter, I was.
item 14.
Lordship,
Yes.
in this matter, I have filed an additional affidavit, some vital facts, Lordship.
What about 13? 13.
There was some
13 is what order is first in 13? The two order, this order is in respect of 14, 15, 16. We have come just now.
I'm paying for 4, my lord.
14 to 16.
Oh, 4 months. Okay.
4 matute it will. Yes,
Yes,
what is
ma'am.
your submission in 4? 4 who took down? Mashvi? You
Yeah.
took. Oh, you took 4
Yes.
additional affidavit.
So,
What is-
my lord, this is a case, my lord, where the CD has already been there, my lord.
13, 14, 15, that order you put in 14, 15, 13 belega, 14, 15, 16. His order, yes. Additional affidavit.
Lordship,
Okay.
fix it on 1 week, Lordship, after on 5th or after that, Lordship. 5th of December or after that.
All right, 5th of December.
Deeply.
4 years, what
Yes,
is to
my
do
lord.
it
My lord, I
for?
will take your lordship to page number 10 is the FIR, my lord.
Yes, give me 4.
Item number 4. The entire allegations, my lord, is against one Pallavi Saikia, my lord, and an FIR has been registered by the ADC in Nagaon, my lord. I will just read the FIR at page 10, my lord.
Yes.
SP Nagaon, allegations of corruption malpractice against Pallavi Saikia, DQM in the connection of the recruitment of educational volunteers under LOCA educational block. I am to lodge an first information report against the allegations of corruptions and malpractice in the recruitment of educational volunteers under LOCA education block. It has been brought to the notice that one Pallavi Saikia is allegedly involved in corrupt practice and irregularities during the state recruitment. The complaint in this regard has been submitted by one Zakaria Ali Ahmed, who has alleged that the selection process was manipulated for personal gain and undue favoritism, thereby violating the norms and guidelines laid down in such
It
recruitment.
is the complaint of
Yeah.
Zakaria Ali.
Yes, my lord. This is a complaint, my lord, has been filed by one Zakaria Ali on the basis of
Where is that?
complaint.
Is it available here?
No, it's not available here, my lord, because it will be there in the city, my lord. We don't have the copy of that, my lord, but the Pallavi Saikia, my lord, who is, my lord, the main accused in this FIR, she was granted interim bail by this honorable court, my lord. At lordship may kindly see at page 20, my lord.
Who are you?
My lord, we are the educational volunteers, my lord. So we are working, my lord. We have been called in the office of the deputy commissioner, my lord, and from there itself, my lord, since she was also called and she left, my lord, she was left, and thereafter she came to anticipate bail application. We have been arrested, my lord. 3 persons have been arrested, my lord, and today it is already 49 days, my lord. I've calculated, my lord, 49 days in custody. And the allegation is, my lord, criminal breach of trust, my lord. ADC has lodged an FIR, my lord, against Pallavi Saikia. We are being arrested, my lord. My lord, may kindly see, my lord, page 21, my lord. 21, my lord. Even, my lord, when the, yes, my lord. Even, my lord, when the policeman on the very first day, my lord, wanted a remand, my lord, they could not even satisfy the court below, my lord. Lordship may kindly see the order, my lord, at page 15 it starts, my lord. At 16 it is observed, my lord. Lordship may kindly see page 16, my lord. And, my lord, in the remand also, my lord, on being asked, my lord, may kindly see the down below the paragraph.
Yes,
my
what is
lord.
there in the CD?
My lord, one Zakaria Ali Ahmed, my lord, he is also one of the education volunteer. He lodged a complaint before a deputy commissioner, my lord. Anything there, my lord, this person, my lord, they collected some money, my lord, in order to purchase some, my lord, materials, which are used in, my lord, pressing process, my lord. And that has been done, my lord, as, my lord, directed by the, my lord, Pallavi Saikia, my lord, who is the, my lord, district quality manager, my lord. Then on the basis of his complaint, my lord, additional deputy commissioner lodged an FIR, my lord. And on the basis of that FIR, my lord, this person has been arrested, my lord. And with the other person who collected money, my lord. And they said, my lord, they give the money to the, my lord, Pallavi Saikia for purchasing some, my lord, materials for which are used for educational purpose. But in fact, my lord, those materials are supplied by the government, my lord. This is the allegation.
So he is one of the collectors.
One of the collect. He is also one of the, my lord, educational volunteer, man.
I am one of the education volunteers.
He collected money from whom?
Collected money from the, my lord, other volunteers, my lord. It is
Other
the allegation, my lord.
volunteers.
One has come before them, my lord, saying that they have paid us the money, my lord.
As per the statement of Zakaria Ali Ahmed, my lord, he said he is also one of the educational volunteer, and this arrested person along with 2 others, my lord. They collected money from him, my lord. There are other volunteers also there.
How many days? 46.
My lord, 49 days, my lord. My lord. And the allegation is breach of trust, my lord. 60 days is the mandatory period, my lord.
Hard learned counsel for the petitioner on an additional PP. This is an application under so and so. The allegation is reflected in the FIR. Check. Now you go to paragraph 3, page 21. Okay. Order dated 10/11/25. With the fourth line, instead of present petitioner, main accused one Pallavi. What is her name? Pallavi
Take man.
Saikya. DQM. DQM. Para. The CD which had been called for in connection with another application is available with learned additional PP. Upon perusal of the said PP, it submitted that there are allegations against the present petitioner of collecting some money from other educational volunteers for the purpose of purchasing educational materials, although the same are supplied by the government. Para. The petitioner has already spent 49 days in custody, and the investigation would have progressed by now. Having regard to the above as well as the nature of the allegations, the prayer for bail is allowed. You see, having regard to that, and also the fact the main accused has been granted interim pre-arrest bail. By order dated 10/11/25 in AB 2640 of 25. 50,000 one surety.
Abhilash Malva. PGM law.
May it please your lordship. The allegation of murder, your lordship. Your lordship, today 85 days, I am not on the merit of the case, your lordship. Only considering the period of detention, your lordship.
Earlier, my lord, we received the case diary, my lord, but since the postmortem report was not available, my lord, so we sent the case diary for to collect the postmortem and submit up to date, my lord. But we have received, my lord, an intimation, my lord, postmortem report is not ready, my lord.
Today is 85 days, your lordship. 86 days, 86 days, your lordship. Forwarding report is at page 21, your lordship.
My lord, I am sorry, my lord, in this case, charges submitted, my lord. Case number 226/2025. dated
All right, then call for the TCR.
Call the teacher.
Submitted that charge sheet has already been submitted by CS number so and so.
226
Scan copy
2025.
of the TCR
Dated 27/11.
with CDN postmortem report.
Obvious. Seven, 12. Obvious, Deepak.
18 charges submitted, madam.
Yes, Your Lordship, 3096 allegation of robbery, Lordship, and it is traveled by the Mr. Frascas, Lordship. You have the, at your Lordship, kindly consider 49 days, Lordship, as on today, Lordship. Actually, he was arrested on 10/10/2025. 49 days behind the bars, Lordship. Census from
4 lakhs,
4 lakhs, exactly not.
same order. Okay. Scan copy.
Lordship, may I submit, Lordship, then I may be allowed to withdraw it and try my luck there in the tribunal. Because this is,
Hence that.
yes, Lordship.
Submitted, the charge sheet has already been submitted in the case. Learned counsel for the petitioner submits that he shall appear before the learned court below and apply for bail. Accordingly, the instant application is disposed of with the observation that as and when the any application for bail is made on behalf of the learned, before the learned court below, the same shall be considered as per law.
Obliged, Lordship.
His postmortem report was called for, my lord. Lordship.
Not received a postmortem report yet, Lordship.
Can it be on, my lord? Wednesday, my lord. On 3rd, my lord.
Third. Can you get it?
Lordship, not received, Lordship.
On third, can you get it?
Yeah, the report that is a postmortem report is still pending in GMC. So Lordship, then third of.
PM report not received, list the matter again on 3rd of
You can pull some.
December.
Obliged.
I may, Your Lordship. I've been arrested on the basis of a Facebook post minutes. The FIR is at page 12, if you may kindly.
I have not received a case diary, Lordship. Case diary not received.
I may be heard, my lords. They have invoked sedition, my lords. Prima facie, there is no such case, my lords. No case can be made out for sedition, my lords. Please come to page 12. I have been behind 16 days, my lords. Please come to page 12, my lords. This is to inform you that on so-and-so at so-and-so, informed that a person, namely so-and-so, is commented provocative post on his social media Facebook account as প্ৰতিটো ইলেকশ্যনৰ আগত দেখোন এটা বোমা এটা ফাটে খাটাও পাছত আৰু বাকীখিনি কাহিনী বনি যায় with a view to politicize the last bomb blast in Delhi, which is a matter of utmost national security in this serious crisis situation, and so after they take cognizance. Now, my lords, now kindly come to the sections. They have invoked 152, my lords. 152 is, my lords, sedition. Now, can this be invoked? This is an ambiguous statement, my lords. A trivial statement that the person has made. Can this statement has that ingredient to invoke sedition? There is a line of judgment by the Honorable Supreme Court which says, my lords, for sedition to be invoked, there has to be a incitement of violence. There has to be a direct connection, direct nexus. There is nothing. It's just that just before election. It could be a political statement that I don't know. It could be a statement which would also mean that he is quite concerned about the way things are happening. So, my lords, this time, my lords, it's a prima facie case of giving me an interim bail, my lords. And if you lordship see the other sections, if we set aside sedition, 192, 196, 197, all of these, my lords, the punishment is below 5 years. Now, my lords, Honorable Supreme Court in Imran Pratapgarhi has made it quite clear that for offence below 5 years, there has to be a preliminary inquiry. Only to frustrate Imran Pratapgarhi, they have invoked sedition. So, my lords, at this time, let me grant me interim bail, my lords.
Even a sorted will produce the case there also.
It's a trivial statement, my lords. Needless. I am a school teacher, my lords.
Being a school teacher, it should not be comment like that also.
I have suffered enough. Let's have some sympathy, my lords.
For that unfortunate incident, people make me so sorry, but sadness. Despite of this, they are getting other things.
Suffer, my lord. I have a leg injury in my left leg also, my lords. Injury may be considered, my lords. It's a trivial statement, nothing untenable in law.
I think we have allowed in a similar case earlier. All right, since the prayer is for interim, call for the CD, hard learned counsel for the petition, learned additional PP, this is application under so and so. The only allegation against the petitioner is that he had made a social media post within inverted comma before every election. We see there is a bomb blast like this, and after that there is a story. Was the contention of the IO of the informant that such post may cut that line. Second line, last line to cut it in. Call for the case diary. CDS call for has not been received. Having regard to the nature of the allegations and the fact that the petitioner has spent 19 days in custody, provided that in the interim that he shall be released on interim bail of ₹50 security for like amount to the decision of the learned Elaka magistrate. Is the matter again on
16 days, my lords.
16 days
Custody.
Much obliged, your lords.
Item 21.
Item 22 are out of the same apparel.
Item 21, my lord, the lordship has granted bail, my lord, in the main case in which you was arrested, my lord. It's a common affair, my lord, all over Assam, my lord, page 13, my lord. My lord, page 13 is the common affair, my lord, that Bill Ashit Khana regarding my lord. And there's a prayer for shown arrest, that is page 18. You know, the persons which are named, my lord, in the prayer, my lord, I'm not among them, my lord. I used to, my lord, take sandas from different institutions, my lord. They named the main leaders of that institution, my lord. Page 18.
Several businessmen and entrepreneurs were examined, and they all have said that yes, they have demanded and collected money from, and even if some places they have
CDs received.
CDs received. Even if some places there such type of incident took place that they have shuttered down the business place, lordship, also for collecting money, lordship.
But whether there is any specific allegation against me, my lord, because the main case where I was arrested, my lord, and that I was granted bail.
Lordship had gone through the earlier case, one dispute, lordship, one person.
That incident of kidnapping.
Yes, kidnapping, lordship.
And that is a specific incident with specific.
But here
It's a general incident, general FIR, my lord, all over Assam. And my lord, the page 18, my lord, is the my lord, the prayer of the my lord, IO, my lord, where my lord, my name is nowhere mentioned, my lord. So, brief facts of the case, my lord, that paragraph, page 18, bottom paragraph, my lord.
Yes, what is the specific allegation against, material against him?
Some persons are implicating him, Lordship, and along with the other persons, his involvement is there, Lordship, and some person not stating his name. Several witnesses were examined, apart from businessmen, entrepreneurs, are different states of, districts of the state, Lordship.
So whether any specific incident related to me, my lord.
All right, you marked the CD.
Segment,
But there cannot be any specific allegation against me, my lord. It's a general allegation against all.
How can you say there cannot be? It will CD will reveal.
Lordship. And similar case, item 22.
Item 22.
Same, Lordship, I have flagged everything. Lordship.
All right. Chamber.
Oblige your lordship.
Lordship, upon the instruction of my client, they wants to withdraw the case. Withdraw the bail.
As prayed for by Mr.
And Sasita already late.
You are?
K. Bhattacharya.
Bhattacharya. Learned counsel for the petitioner. Matter is dismissed as withdrawn.
Session is cancelled.
Kindly pass over the matter for the time being. 26.
76 TCR received, but we have some, here, Lordship, one case is pending regarding the maintainability of the case. And I act where PA is maintainable or appeal is maintainable. So a case is pending in before Honorable Court Justice Lordship. That is on the period of judgment on Wednesday. So we can go through some judgment Lordship regarding this, whether it's the maintainability of the petition. So Lordship, let me appear and my submission is that after that judgment Lordship will take over the matter, then it will be benefit for us. A petition on this.
NIA has not investigated the matter. Is it not?
Lordship.
NIA Act. NIA Act. NIA National Investigation. NIA Act, no, I think. Investigation Agency Act.
Let him appear, Lordship. I will go to the petition also, Lordship, in this regard. Let him appear.
All right, sometime.
We have sometime.
না এখন লেট হবে নেক্সট কল করে দিও $77 CDs here.
Yes, my lord, 17.
None appears list on Monday. CDB returned. Time. It's on item 66 or 30.
My lord, 24, my lord, charge sheet has been submitted, my lord.
It is not your entry, my lord.
Charge sheet number has been given, my lord, without the date, my lord.
It is not your entry, my lord.
Hmm?
It is on entry, my lord.
So what do you want to do? You appeared there.
My lord, entry may be absolute, he will appear before the.
Not absolute till only till then.
Till his appearance,
time will be-
Hmm?
till his appearance before the trial. Produce.
Learned counsel for the petitioner, learned additional PP submit that CS has been submitted by
Only CS number is
CS
66
number.
oblique 2025. my lord. That may be CS number 66 oblique 2025.
Date nil. Dated nil. As prayed for by learned counsel for the petitioner, this petition is disposed of. The direction that the petitioner shall appear before the learned trial court in a period of 15 days from today. Upon such appearance, if any application for bail is filed, the same shall be considered as per law. Till then, the order of interim pre-arrest bail shall dated shall remain in force.
I please your lordship. First occasion, lordship, this honorable court called for the up-to-date CD.
The up-to-date CD we have not received, my lord.
Up-to-date CD not received. List again on so and so interim order passed earlier to continue till the next date of listing.
Master place.
1812.
Wait, well, up-to-date CD has been called for. Well, on regarding that, one of the petitioner has, after getting interim bail, well, he appeared before that. And the lordship has told that other 3 persons also to be examined, to be recorded as Tamil. This is, my lord, absolutely a civil matter, my lord. Absolutely, well, that has been misused. If your lordship kindly see, Annexure 1, my lord.
They are on interim, my lord.
I'm on
Have you received or not?
Okay, up-to-date CD not received, my lord.
All right, up-to-date CD not received. List again on so and so interim order passed earlier to continue.
Which date?
My lord, that will be in the month of January, my lord.
All right.
Okay, calendar upon devotion.
January. Publish.
May I please your lordship? My lord, this honorable court was pleased to.
Received.
Yes, that is not received, my lord.
Same order.
8 January. 8 corridor. 8 January.
Interim to continue. Next.
Kindly interim order may be put. Oblige.
What is this bunch?
Very hard disk.
Regarding the genuineness of certificate, lordship produced by the customary submitted that they have received the CD.
Lordship has made some query, my lord. Whether, my lord, any report from the university concerned, my lord. Which says, my lord, this mark sheet submitted by all the candidates, my lord, these are forged, my lord. So, my lord, I have, my lord, furnished one report, my lord. Along with the, my lord, details of the each and every candidate, my lord. How was investigation done, my lord? Actually, I have asked the investigating officer to make a specific note against each and every candidate, my lord. So this is the report from the Techno Global University, my lord. And the, my lord, in respect of report, in respect of each and every candidate, my lord, who are the petitioners in this petitioner, my lord, in connection with, my lord, that CIDPS case number, my lord, 15/2025, my lord. So, lordship may kindly peruse the, my lord, report, my lord.
What was the original case? I mean, the allegation.
Page 30 annexure 9, affair, lordship. Based on a complaint, lordship,
this FIR has been lost, saying that lordship, the candidates have
Page
given
13.
page 30 lordship in at AB number 1983, item number 28. Is the FIR. The section 318, 386 and 340 lordship. May I read? I'm lodging a complaint based upon information received from reliable source regarding matter of grave concern that during the recruitment process of graduate, postgraduate teachers under the education department, more than 50 candidates have submitted pass certificates allegedly issued by Techno Global University MP, which are reportedly fact. In view of the seriousness of the matter and its complicity in the integrity of the recruitment process, I request you kindly. So accordingly, it has been registered. And thereafter, those particular documents have already been seized by the police. I have also annexed those seizure lists. And thereafter, we appeared before the IO. Statement also recorded. Now, Lordship, the thing is that it is upon only based on documentary evidence. Now, these documents are within the custody of the investigating agency, lordship.
My lord, this is not
So
the case. My lord.
further-
The
further-
case is that, my lord, through some middlemen, my lord, they have procured this certificate, my lord, intentionally knowing that these certificates are forced and fake, my lord, and they submitted before the, my lord, for my lord, this post-graduate examination, my lord.
Lordship, although they
So,
have
my lord,
lordship-
I have strong objections, my lord, to granting them absolute bail, my lord.
although
And
lordship, they have-
some more investigations are yet to be completed, my lord.
So although they have relied upon those documents, they have not been selected also. I have categorically stated in the petition, lordship. So lordship, no prejudice, so further custody intention not required, lordship. Even in a similar situation, lordship, exactly the same charges, lordship, this honorable case had already passed an order, lordship. This was done, of course, in 2022, lordship, during the recruitment process of the police, lordship. Same charges using forged documents, the computer efficiency certificate, and finally, this honorable court held that lordship, this was allowed, lordship. Yes. May I submit the copy of that order, lordship? As well as lordship, may please to come to paragraph number 9. So for the paragraph number 2 is the charges, same charges. And from paragraph 9 onwards, lordship. Trial. One more submission, so far the document is concerned, these are not valuable security, lordship. Paragraph 10, lordship.
All right, anyhow,
From paragraph 9 onwards to paragraph 12 Lordship. The apex course, Mr. Decent, will discuss Lordship elaborately. So far, the Lordship, genuineness Lordship, it is during the trial Lordship, onus lies upon the petitioner. So Lordship, therefore, Lordship, further interrogation at this is not required. So this may be absolute Lordship.
The entire case there is along with us, my lord. The case there is shows, my lord, how they have paid money, my lord, to procure this certificate, my lord. But their custody interrogation is very much necessary, my lord.
Already
And
they
I
appeared.
pray,
Lord.
my lord, their interim period has been maybe rejected, my lord. So there are materials, my lord, that has been collected by the IO, my lord.
Yes, any other council has submissions?
Right.
Question number 34, my lord.
Yes, item
34, my lord.
34. Yes, 34.
Yes, my lord. 34, my lord, I beg to, my lord, read out one paragraph in my petition, my lord. That the petitioner begs to state that
Para?
para 3, my lord. That the petitioner begs to state that he passed BSc in first class in the year 2018 from Bolanath College, Dubri, under Guwahati University. In the meantime, the petitioner noticed that many candidates are being appointed in government jobs from the time to time on the basis of their B.Ed degree obtained in distance education mode from Techno Global University, Madhya Pradesh, through an education center at Dubri run by one Manwarishan of village so under district Dubri, my lord, Assam. Accordingly, the petitioner being satisfied on the feedback of B.Ed certificate, he also in good faith obtained similar B.Ed degree in the year 2023 in distance education mode from Techno Global University, Madhya Pradesh, through an education center at Dubri run by said Manwarishan. My lord, in this case, my lord, all are, my lord, graduate, my lord, and B.Ed certificate, with B.Ed certificate, my lord, they applied, my lord, in good faith, my lord. And in the scrutiny stage, my lord, this obviously, my lord, petitioners also aware that this kind of, my lord, certificate, every certificate should be, my lord, scrutinized. Then they will be called for, my lord, interview. And in the initial stage, my lord, in the scrutiny, it is found, my lord, these, my lord, the certificates are doubtful, my lord. Accordingly, my lord, FIR was lodged, my lord. But my humble understanding is that, my lord, after passing graduation, my lord, no person, my lord, knowingly that this is a fake document will apply, my lord, because it is always under scrutiny that, my lord, whether it is, my lord, fake or genuine, then they will be called for interview and appointment, my lord. So, my lord, they are misguided, my lord, educated people, my lord. My humble submission is that, my lord, my lord, custodial interrogation may not be necessary in this case. They will face consequences, my lord. In the trial, my lord.
It is clear, my lord, that he has done it intentionally, my lord. By depriving, my lord, many meritorious candidate of the, my lord, nation, my lord.
No, my lord.
Thereby they are depriving the actual meritorious candidate, my lord.
No,
The offense is, my lord, very serious in nature, my lord. And there are materials, my lord. Why I am submitting, my lord, there are materials collected by the IO against each and every of the petitioner, my lord.
Let us hear all the counsel for the
My lord.
petitioners, then you
But
can
this part, my humble submission.
comprehensive reply.
Palace. No.
Please, your lordship. Lordship, item number 49, your lordship. I have already quoted in my paragraph number 5, your lordship, that I am no longer connected in this case, your lordship. That in this state, the petitioner is not connected in any manner with the commission of the allied offense. It is stated the petitioner is a Molavi, your lordship. Being a Molavi, he is a religious scholar and expert in Islamic law and serve as a teacher, spiritual guide with the Muslim community. It is categorically stated that being such a person, he cannot indulge himself in fabrication of past certificate alleged in the FIR, your lordship.
Alright.
Obliged.
Item number 50, my lord. Because the petitioner herein, my lord, is a school teacher. He is neither a candidate and nor is it affiliated with the university in any concern, my lord. One of the candidates had approached him regarding pursuing this DL. So his only role was referring that candidate to another person who was otherwise working on behalf of the university, my lord. Now, what role is there to be played by him, my lord, because the allegation herein is forgery of the documents. This petitioner herein is neither connected with the university, is not connected with either the procuration of the documents or the furnishing or submission of the documents to that effect. Now, my lord, do not know what is there in the case diary vis-a-vis this petitioner, my lord. Thus, he is otherwise a school teacher, my lord, not connected, not affiliated in any manner. He has appeared, he has given his statement, my lord. So your lordship will examine that aspect, whether his detention in that regard is connected or not.
Where have you stated para?
Para, my lord, your lordship will kindly. Para 2 and my lord. Para 9, my lord. 9 and 10. 2, 9 and 10, my lord.
Yes.
And regarding, my lord, the other item number 51, my lord. Now, these two petitioners here, my lord, they were working because the university, my lord, has an agent in every state, my lord. Through which, my lord, that is there for every university, my lord, through whom admissions and all are procured, my lord. Now, these two persons were deputed for the purpose of procuring admission for students in the university. Now, the university in itself is a genuine university. Even my learned friend will also agree with to that effect, my lord. These petitioners were only working as agents on behalf of the university. He has no connection with the candidates because his role would be to procure the students for the admission. People will get admitted in the university, they will pursue the course and get their degrees. Any other person, what specific role any other person has to play regarding this allegation, that is not attributable to these two petitioners. That your lordship will, in this case, my lord, my contentions are at paragraph 6, my lord, 6 and 7. 5, 6 and 7, my lord. They have also appeared, my lord, and recorded their statements. So your lordship will also kindly examine their individual role, whether they can be connected with the other students in any manner. I'm deeply aware of that.
My pleasure, Lordship. Lordship, item 45 and 46, Your Lordship.
Yes.
In item 45, Your Lordship, only one petitioner, and 46, 3 petitioners, all are students, Your Lordship. By profession, they produce their documents on TET, Your Lordship. They have no direct connect with the institution. Actually, they are also the victims, so they invest time, Your Lordship. They also the victims, Your Lordship. If their documents subject to question and case is pending, Your Lordship, they cannot use further, Your Lordship. And on interim, Your Lordship, all are appear and cooperate the investigation, Your Lordship. Long terms and further detention.
You were one of the applicants for the job.
Lordship.
You applied for the post.
Applied. All are student applied to the TET, but not considered, Your Lordship. Custodial interrogation not necessary, Lordship, in this cases, Your Lordships.
Yes. All right. Anybody else?
One thing I'd like to point out also. So for the item 24, also regarding the genuineness of the university, lordship, it is a genuine university. I have annexed the recognition order. Lordship, may kindly see page.
And that is not contested by prosecution.
Yes, lordship. And so far the using the document also.
You are on item number?
Item number 28 to 30 and 35 to 41. And although they will, let's say, they applied the application, lordship, their candidates
28 to 30 and
28 to 30 and 35 to 41. And I have make a statement, lordship, in the petition, lordship, although they have applied, lordship, their candidates as well as the application has been rejected, already rejected. So they have not gained anything from by using the document, lordship. And so far this genuine lordship, it is in future lordship, during trial lordship, it will be. And while we appeared before the IO lordship, we have been asked to sit for more than 7 to 8 years lordship. And medically also we have been examined. By relying this order lordship, our order may be absolute lordship.
Yes,
Judgment lordship.
anybody else?
Obliged lordship.
Yeah, please, your lordship. Lordship, item number 32 and 48, lordship. Same lordship, they were the student lordship and they obtained the certificate. But whether the university is fake or not, they have no any knowledge, lordship. They are
You are also rejected.
lordship. Lordship. Seems lordship.
Lordship, item number 31 and 42, lordship, both are student lordship. They are victim of circumstances, lordship. They appear, they have already appeared and recorded their statement, lordship. So further custodial detention may not be required, lordship.
Yes.
Lordship, 32 and 40, they are also appeared before the IO after getting interim, lordship, and their statement already been recorded, lordship.
31 and 40, huh?
32 and 48, lordship.
Is there anyone in this whole bunch who has not appeared before the IO?
I think someone, counsel has not appeared, my lord, for 3-4 matters, my lord. He is in legs in court number 23. Otherwise, we have all appeared. And
Which items are those?
my lord, that I am unable to say, my lord. He just told me that.
Okay, you will come.
Yes, my lord, one more point, my lord, Lordship will examine the punishments in all these cases is 7 years, my lord. These are all noticeable under section 35(3), my lord. So if their cooperation can otherwise be procured by issuance of a notice, they have all gone and participated in the investigation with the protection of this honorable court's order. Their participation is otherwise not there on record. That is another aspect, your lordship.
My submission may be recorded, my lord, whatever I have already submitted the, my lord, note of. And case diary also available, my lord, wherein it is said, my lord, all the students, my lord, they knowingly, my lord, they have filed this, they have submitted this, my lord, pass certificate, my lord. University is genuine, my lord. Certificate they have produced, my lord, they have submitted, these are all fake, man. And investigation is going on, my lord, it will take some time, man.
Evening.
CAV, huh?
Wherein, my lord, I was granted interim protection, but on the last occasion when the case diary was called, so it was reported that charge sheet had been submitted. So your lordship was pleased to call for the scanned copy of the charge sheet, my lord, that has come, my lord. This matter, my lord, involves even lordship on last occasion, your lordship also considered this, involves a consensual relationship between, my lord, the informant and the victim. The victim alleged basically two things, my lord. One was the allegation of rape, which by bare reading of the FIR, it becomes apparent that this was not a case of rape. There was also one allegation that he had recorded some objectionable videos on his mobile phone. In the charge sheet, it was very clearly stated by the IO that no such video was found, my lord. In the charge sheet, no such video was found. So the charge sheet was only laid under section 64(1) of the BNS, my lord. That is rape. And the FIR, if the lordship will see at page 10, my lord, it is very clear, my lord, that the relationship was a consensual relationship, my lord.
I could not gather the video.
But I have not gone to the scan copy, my lord.
Is otherwise reflected in the charge sheet, my lord, very clearly. Hence the other section, my lord, 77. That has been,
No, what are the sections now?
now it is only 64-1, my lord. Rape, my lord.
No, obviously, he couldn't get any video. Otherwise, IT Act would have also come in.
Come with one. It was, IT Act was never there, my lord, even during investigation, my lord. Otherwise, on this allegation of rape, my lord, that is not there. And I have been granted interpretation. I have appeared, my lord, and
Hard learned counsel for the petitioner, also hard learned additional PP. CCR has called for has been received. The allegation as reflected in the FIR was that the informant, who was a married woman, was in a physical relationship with the accused. Subsequently, the accused circulated some obscene videos involving the informant through WhatsApp among various people. The case was registered under section 61(1), 77, 3514 BNS. Upon completion of the investigation, the IO has submitted the charge sheet under 64,
64-1, my lord.
only under section 64(1). Therefore, it is apparent that the IO could not collect any material with regard to circulation of obscene videos. And on a perusal of the FIR itself, it appears that the physical relationship between the informant and the accused was a consensual one. Having regard to the above, the prayer for pre-arrest bail is allowed. The order of interim pre-arrest bail dated
11/9/2025.
hereby made absolute on the same conditions. In conditions E and C therein. Petition stands allowed accordingly.
Formal care not received, my lord.
We are on interim, my lord.
He did not receive. List again on interim order passed earlier to continue. Next.
9-1, 9-1.
Deeply obliged.
In this case, search is submitted, my lord.
Lordship, I am led by Mr. Isari Soudhary, Lordship, may be taken up after 2, Lordship.
That sheet is submitted under which section it is available?
My lord, it is not mentioned, my lord.
Not mentioned. After something.
Publish.
Happily, Lordship. I am under interim protection. I am a Sarkari Gambura. I issued a certificate to Imran Latif Borwa, FIR name accused. So on that basis, police called me. I subsequently appeared and police recorded my statement.
Is it Lakhimpur?
Yes, Lordship.
For that case where Gambura issued one certificate.
Showing that, my lord, the persons are all dead, my lord.
Dead.
Now, when he has appeared before the IO, my lord, he stated that since they were no longer living in that locality, my lord, so he presumed that they died. Their certificate, on the basis of that certificate, my lord, the person who is the accused number one, my lord.
All right,
he has
may not,
been dead, my lord.
custodial interrogation may not be necessary now.
Let him cooperate on the investigation.
But learned counsel for the petitioner and learned additional PP. This is an application under so and so. The allegation against the present petitioner that he being the Sorkari Gambura had issued a certificate showing some living persons as dead. And with the help of that certificate, other co-accused had transferred land in the standing in the name of such people to others. Para pursuant to interim protection granted by this court, the petitioner has appeared before the IO, wherein his statement has been recorded. Wherefrom it prima facie appears that the act of the petitioner was not intentional. So be that as it may, having regard to the facts and circumstances, the custodial interrogation of the petitioner is not considered necessary. Accordingly, the prayer for pre-arrest bail is allowed. The interim order passed on 25/9/25 is hereby made absolute on the condition that the petitioner shall cooperate with the investigation. Petition stands disposed of accordingly.
After some time, Mahajan is appearing.
May please, your lordship. Lordship's case diary was called for. Lordship.
Yes, with the FIR.
Page number 9, lordship. If lordships comes to translated and type copy. My lord, the informant is someone Kusmo Hasnusi happens to be, my lord, the aunt of the accused person. My lord, may I read the FIR? Informant most respectfully beg to state that on so and so at around so and so, the accused person taking advantage of my husband's absence at home entered my house and showed obscene signs to me, and due to my denial tried forcefully to do wrongful act and grabbed me by putting me down on the floor. At this time, my two daughters came to know and shouted and cried, because of which the accused person ran away. In respect to the aforesaid incident, written Ejahar was submitted before the Lanka police station. It should have been. Even after having sufficient evidence regarding the incident, the Lanka police did not do the necessary investigation. No case has been registered against the accused person. No steps have been taken against the accused person. Xerox copy of the Ejaharis were enclosed, and it was requested in view legal action will be taken. So, and my lord will kindly see the sections that were under which the case was registered were 64(1), 329(4), 79, and 62. And with all respect, my lord, there appears to be no ingredients regarding 64(1), because this is for punishment for rape. 62 is for attempting to commit an offense beyond 10 years, and 329(4) is criminal trespass of house, and 79 is obscene language. And 329(4), my lord, with all respect, my lord, 329(4), my lord, she is my aunt. I have gone to their place. I'm not denying that aspect. Now 329(4) has been slapped against me. Obscene language, maybe, my lord, there is some ingredients regarding obscene language, but 64(1), my lord, with all my respectful submission, my lord, that the 64(1) is not there. And having regard, my lord, keeping aside all these aspects also, 183, my lord, under 183 statements have been recorded. Now I don't think there is need for any. My lord, I may be allowed to go and cooperate with the investigation, may be allowed to appear before the IO, subject to what my learned friend says.
Yes.
183 of the victim has been recorded, my lord, and he is implicated, my lord. He, my lord, hold her from behind, my lord, in her says, then he, my lord, pushed her in the ground, my lord, trying to commit the offense. Then she make even cry. Her two daughters were, my lord, they were studying in the nearby room, my lord. The daughters came there and they saw, my lord. Was trying to commit an offense, my lord, by pushing her in the down.
Daughter's statement has been recorded.
Recorded, 183 recorded, my lord.
How old?
They are, my lord, 18 years.
18.
Him is 42 years.
Victim is 42 years. And
Daughters
as-
have been implicated.
Daughters are also implicated. And my lord is so that
But as my learned friend has stated before this honorable court, trying to, my lord, the incident has not happened. It was a
that is also an offense, my lord.
already statements have been recorded, my lord.
(64)(1) will not come in definitely.
Rape will not come, but it was an attempt, my lord, to commit an offense.
What is the punishment? Five years.
Come. 62 will come.
Well, 62
That
will
is
not
what
come.
attempted rape
Attempt, my lord.
simpliciter will be 5 years.
He attempted, my lord. 62.
Half of the punishment. Third learned counsel for the petitioner. And an additional PP. There is an application under so and so. Allegation as contained in the FIR is that on the date of occurrence, the petitioner taking advantage of the absence of the husband of the informant entered her house grabbed her by putting her down on the floor, and upon arrival of her two daughters, the petitioner ran away. The case is registered under section 329 in bracket 479 within bracket no in bracket na stroke 4 with stroke 62 para offense under section 64 within bracket 1 stroke 62, that is attempt to commit rape, is punishable 5 years in para it also appears that case from the petition that there was prior dispute relating to land between the parties regard to the of as well as the nature of the allegations. Till interrogation of the petitioner may not be necessary. Accordingly, the prayer for pre-arrest bail is allowed, provided that the petitioner shall appear within a period of 7 days from today before the IO. And he shall not try to influence or intimidate the witnesses. Petition stands allowed accordingly.
Obliged, deeply obliged.
Lord, the first of all, it's a very unfortunate case, my lord, the fight between the brothers, sisters, my lord. And therefore, my lord, your lordship, look into the matter in the sense that these people are not criminal in nature, they do not have any criminal antecedent. Lordship will find 2 criminal cases and 1 civil matter is pending between them in regard to the ancestral property. Now, my lord, in that view of the matter, your lordship will see that there is a prima facie case, your lordship is already granted interim bail. Now, if I. It is a PM report tonight, post. Lord, possibly, my lord, learned friend.
Not received.
Case receive postmortem report is not, it is a required receipt. Postmortem
All
report.
right, since you are on interim, wait. CD received, but
Interim?
postmortem report is not received, which according to learned additional PP will be necessary for deciding the application. Hence, list the matter again on so and so. Interim order passed earlier to continue till the next date of listing.
63 also similar matter, Mala.
17 to lordship may fix on
62,
17.
63.
Lordship is fixing on 17th. 17.
17, 12.
Obliged. Oh.
Before going to the FIR against us, Lordship, I am drawing your Lordship against the attention. The FIR lodged by us.
CD is received.
Yes, because
Yes.
our FIR is the first FIR. That is, your Lordship will find as page 18. On it.
Yes.
This is our, with due respect, back to state that I so and so resident of the above noted address on 29/2000, this is the date of incident, Lordship, 29/2025. At about so and so, the below noted accused number 1, Ahad Ali, illegally entered into my house and threatened me to kill and burn the house. Acting on the threat, I along with my younger brother, I proceeded towards Manikpur police station to report the matter. And while we were on the way, I came to know that at about 9 AM, my house was again attacked by Ahad Ali along with other accused person, namely so and so, by trespassing into my property and attempted to burn my house by setting it on fire. When my son-in-law Mahmood Ali, he is the petitioner number 7, Lordship, tried to stop them, the accused person poured petrol on his body and set him on fire, causing grievous burn injuries on different parts of his body. He was immediately taken to Fakhruddin Ali, so and so. Your Lordship will kindly come to page 21. Mahmood Ali, Lordship, he was under treatment from admitted on 29/2025 and discharged on 24/9/2025. My lord, despite of this FIR was not registered. Subsequently, we filed the CR case, that is, your Lordship will find page 22. Complaint case on 7/11/2025.
Page 20.
22. And relevant your lordship page 24, para 4, just one paragraph. Why we file this CR case?
Yes.
Para 4, page 24. In this regard, the complaint was lost on and a complainant lost an Azahar before the OC Manikpur police station on 21/9/2025. But
Yes, we have understood.
lordship, that
Yes.
case
Now,
was,
what is the present FIR?
this CR was filed on 7/11/2025, page 26. And on that very day, their FIR has been lost after knowing that we have filed this CR case. That is page 9. And they have lost this FIR lordship on 7/11 at 9:37 p.m. of the same incident. Page 9 is the FIR against which we are seeking bail lordship. Page 9.
Yes, CD.
Lordship, as per medical report, injury is grievous and burn injury on 29 around 10 AM. And lordship, treated by surgery and present was admitted in the hospital lordship for surgery. And bleeding from nose, laceration was there lordship. Injury is grievous, but weapon is as per FIR lordship, it was iron rod. And witnesses concerned lordship, they have implicated lordship. কবির আলী, হাসান আলী ও মাহমুদ আলী ফয়েদিক টানি লগে হাসান আলী ঘৰ ওচৰত খেতিত মাটি লৈ যাৰ আসামী নবীৰ আলী আৰু কবিৰ আলীক মাৰপিট কৰি ৰডেৰে বাও ভৰি ভাঙি দিয়ে। So all are implicated in this. Apart from one petitioner, I have not found. Name is Ahijul Islam. Name is not taken anybody.
FIR lost after 1 month, 20 days.
The witnesses are not stating against anything against petition number 1 and 6. Ayub Ali and Ahijul Islam lordship. Other than that, all witnesses are implicated, yes, and apart from the complainant statements, in the injury report concerned lordship, it is grievous. Yes, sir.
How many days you are saying treatment?
Incident is of
29/2025.
yes.
They have also mentioned, page 9. FIR lost on 7/11/2025. On that day, our CR case was filed. After knowing that, they lost this FIR. Your lordship will find at page 15, time of lodging the FIR, 9:37 p.m.
What is the place of occurrence? Informant's house or their house?
Paddy field is in between the house.
Hmm?
One paddy field is in between the two houses, accused and prisoner's house. Going to the trace method.
House of Hasan Ali.
House of Hasan Ali. House of, House of Hassan Ali in front of one petty field of Qasim Ali and House of Abdul Rahim, petty field accused Hassan Ali. Both the houses in front of them and in the mid portion, the petty field is there. Lordship. So not very long distance.
Totally, he was seriously injured, Lordship. He was under treatment for 5 days from the date of incident. Petitioner number 7. Itu kedin asile.
Nine, discharge from 9. Discharge from 9.
But the allegations in the FIR are very much corroborated by the medical evidence.
Not one thing your Lordship may notice, how many days he was under treatment. The victim. If such kind of injury is there. Because our FIR, we have filed on the very next day. That was not registered. But their FIR on that very day, on 9:30, FIR was registered.
Who knows whether you went or not?
Although the case FIR was lost after 120 days. So, some doubt, Lordship,
It is possible they did not find anything in you.
Alert, yes, maybe Lordship granted bail, Lordship, we will cooperate with the investigation, Lordship, as and when call. Persons are also injured in petitioner side.
What was the injury?
Injury was Lordship. Burn injury and broken of legs, I think. Burn injury, right over side neck and face swollen, upon back and arm. Both bone, left leg.
Left bone, left leg.
Left leg broken, bone was broken, Lordship.
And what about iron rod, something you mentioned?
Iron rod, as per statement of the witness, I have gone for Lordship. They have said that yes, they have taken to the pedophile and 2 persons were assaulted by iron rod.
These are not cases for anticipatory bail, hard-learned counsel for petitioner. Traditional PP. Application under so and so. The allegation has reflected in the FIR. Paragraph 2 of the bail petition here. It is submitted on behalf of the petitioner that it is the petitioner side that who were assaulted by the present informant side on 20/09/25. The petitioners had gone to lodge an FIR at the police station on 21/9/25, but no case was registered. Subsequently, on 7/11/25, they lodged a complaint case against the petitioner, against the informant side. And on the same date, the present FIR was lodged at 9:30 p.m. by the informant against the petitioners. Submitted that from the above evident that the person of the informant is an afterthought Also in view of the fact that the FIR has been lodged more than a month after the alleged date of occurrence. Learned additional PP with reference to the case diary and the injury medical report submits that the allegations made in the FIR are fully supported by the PD. The medical report indicates fracture of the leg and burn injuries over different parts of the body. Statements of the witnesses clearly implicate the petitioners, except petitioner number 1 and petitioner number 6. Having regard to the above, the prayer for pre-arrest bail in respect of petitioner number 1 and petitioner 6 are allowed. It is directed that in the event of their arrest, they shall be released on bail of ₹1,000 each. One surety for like amount to the upon the condition that they shall appear before the IO within a period of 7 days from today, and shall not try to intimidate or influence the witnesses. The prayer for pre-arrest bail in respect of petitioners number 2, 3, 4, 5. How many are there? 7 and 7. 10 rejected. Petition stands disposed of accordingly.
And petitioner number 7 is the victim lordship. He was under treatment for 5 days lordship. Considering that lordship, he may be lordship.
Is that there in the CD?
That is not in the CD lordship, because CD is.
Because our case is in, was not registered.
According to you, there is material against him also. Yes.
But so
You may be victim, you may have got hurt in the counter attack. That is a different case.
Case 21 lordship, he was a treatment lordship. He considering that aspect lordship, as he was the victim in that incident also. Burn injury was there.
When you play with fire, you may get burned. Yes, next.
This case, lordship, the state police has investigated the.
So section 21 for of NI Act lordship. Notwithstanding anything, may I read lordship?
Yes.
Notwithstanding anything contained in section 3 of section 370 of the code, an appeal shall lie to the High Court against the order of the special court granting or refusing on bail. In the inner petition lordship, page 24.
There again,
Page 24. annex
they
five.
have come for bail under.
Order.
Huh?
Order is page lordship 21, impugn order is page 24.
21.
24. lordship.
Impugn order is 24 lordship, annex of 5. Special case number 26 of 25.
Passed by Arnett Session Judge, special judge. And the section is lordship 143(5) PNS.
And regarding this, the maintainability of the petition lordship judgment is pending lordship before the Honorable Justice Kolkata lordship, court number 16. Because delivered to be, they had to be delivered today, but because of this annual lordship, it was postponed for Thursday. So wait for Thursday lordship, then.
It was registered as NIA case.
Yes, lordship.
was never investigated by NIA, so the order that was passed. We constitute as being passed by the session judge only, because it was not an NIA investigated case. Where
But
does
what-
NIA come into the picture?
That is the maintainability of regarding this lordship. I have already told you on Thursday it will be delivered. So later after Thursday lordship, any date fixed?
All right.
Handle.
Next Friday then.
Okay, then Monday lordship. Mondays.
Is submitted that the maintainability of the present petition is a subject matter in another case in which judgment is to be delivered by another bench on Thursday date to deliver. Release the matter on next Monday. Next Monday.
Regarding the lordship, I can place a judgment regarding two bench judgment of Madras High Court.
Was this a case investigated by state police?
Yes, lordship. This can also be investigated by state police.
But here lordship, section 15, 16 and 18 of UP Act was there, lordship. In this case, Madras.
Yes, yes. Here UPI is not involved.
Not involved, nothing is there.
In that case,
Lordship.
whether UPI is involved.
Yes.
UAPS there lordship. Now another cases there lordship where UAPS is not there lordship. Another
That is also fixed for judgment.
lordship. It is on Thursday lordship.
All right, well, let's
But
wait for
after that-
Thursday. There will be some clarity.
Avlal.
59.
May I please, your lordship? Here, my lord, with all respect, my lord. The FIR, my lord, it is regarding, my lord, with all respect, my lord. Supply of coal, my lord. Our case is, my lord. And there, what has happened, my lord? Definitely, my lord, there is an agreement, memorandum on understanding, my lord, that this much coal is to be supplied, and whatever be it, my lord, we have annexed it, my lord. Now, question is this, my lord. They have lost the FIR, this criminal case, that we have not done our part of the job, my lord. Have I made my question clear, my lord? So let us come to the averments of our application, and first the FIR, my lord. FIR itself is, my lord, the FIR is at, my lord, with all respect. FIR is at, my lord, page 13. Page 13. If it is drafted, my lord, definitely with legal expertise, my lord, it goes on and on, my lord, saying too many things. If it is read in totality, it is as if we have defrauded to the tune of 2.5 crore. We have promised to supply coal and not supplying, my lord. And to that effect, how it started, my lord, there is a memorandum of understanding that occurs at page 30, my lord. It stipulates everything, my lord. This is between the parties, Obinap Coal, my lord, and thereafter, my lord, the terms and conditions are there, my lord. Here, my lord, in our application, we have stated two things, my lord. Lordship, may kindly have a look at page 6, para 9. Page 6, para 9, may I just read it, my lord? The accused petitioner beg to state that acting upon the said understanding, the petitioner made the coal ready and dumped it at the designated site, duly informing the complainant for lifting the same.
However, despite repeated requests and communication, the complainant failed to leave the coal within the stipulated time. A GPS geotag that we have annexed, my lord, and that we dump coal, GPS is at, my lord, with all respect, my lord, page 34, my lord. These are the photographs, my lord. They did not lift it, my lord. Absolutely cordial relation, my lord. The quality was not good. Have I made my position clear? If there is, my lord, some dichotomy, it is the dichotomy regarding the quality of coal. But it is nowhere there in the complaint, my lord. Have I made my position clear, my lord? And now, my lord, this is it. And they have not come with clean hands because when they did not lift the coal, my lord, we took the money, they did not lift the coal, disparity in quality, my lord. We paid them back as per us, my lord. Absolutely cordial, page 7, para 11. There are accused petitioner beg to state that subsequently to amicably resolve the matter, the petitioner paid a total amount of rupees 60 lakh to the complainant in banking mode as well as cash. To be precise, we paid 50 lakh in, my lord, cash, no receipt, and 10 lakh kagos fondia. It is to a subsidiary, my lord. They are also not clean, my lord. So many subsidiaries, my lord, this is, they should have mentioned it in the affair. If they would have come with clean hands, my lord. Himalayan Supply, I am related, my lord.
How can you be clean in the coal business?
Oh, yeah, absolutely, my lord. Both parties are not very clean, my lord, to be honest. Lordship is very, very correct. I agree, my lord. My lord, the Himalayan Supply is mine, my lord. Prior to lodging of the FIR or 22/4/25, we paid 10 lakhs to a subsidiary. If necessary, we will file an affidavit, my lord, and let the police verify, my lord. 22/4, kiman disu ami? 10 lakhs, my lord. And that we have categorically stated in para 11 that, my lord, we paid 60 lakhs to the complainant in banking mode as well as in cash. Have I made my position clear, my lord? Para 11, my lord.
Yes.
This part, they have not stated in the first information report, my lord. Now, if this is the case, my lord, we are ready for settlement, my lord. But for dumping and everything, the money we have spent, we have to get it back, my lord. Merely they would say that I want to get back 60 gole kiman thakibo 190 1 crore 90 lakhs. That would be disastrous, my lord. And this is on the face of it, apparently it is a civil dispute, my lord. They have that where leverage has been taken in the form of a criminal case so that we pay back the amount, my lord. And that is why some negotiations are to be there. Definitely we'll pay back, and not that we can pay back 190 during the course of a day. There has to be a period, my lord. But there has to be, first of all, discussion that how much regarding dumping and everything, my lord, whatever expenses we have incurred. Have I made my position clear, my lord? And there is no arbitration clause, no. And there is no, unluckily, there was no arbitration clause because it was drafted by them, my lord. And now, my lord, regarding criminal case in such a situation, the apex court is clear, my lord, with all respect, my lord. May I just read one authority, my lord? 3 authorities we have brought, my lord. This is, my lord, the same sections of law, my lord. Sections of law attributed are, my lord, earlier 420, my lord, and 406, my lord. Now the nomenclature in BNS, they are different, my lord. They are 318(4) and 316(2), all 7-year period offenses, my lord. These are the sections of law, my lord. Oh. Here, my lord, in this authority, may your lordship have a look at Punto paragraph. Lordship may kindly see, my lord. First para, lordship has this authority is before your lordships, my lord. Arshad Niyaz Khan, my lord. Lordship is having a look at.
Yes.
Arshad Niyaz Khan, kindly have a look at para 7, my lord. The factual matrix, my lord. Meanwhile, the parties were referred to the there it was sent to mediation center, my lord, Ranchi, regarding coal possibly, wherein they arrived at a, maybe coal, may not be coal, my lord, arrived at a mutually satisfactory disposition, according to which the appellant agreed to a return a sum of rupees, so 24 lakh, 24 lakhs, my lord, to the complainant in 5 installments. This was, my lord, at the behest of the court, my lord. Same situation, now I come to para 21, my lord. Lordship may have found, my lord.
Yes.
21, my lord. With all respect, my lord. Furthermore, it is pertinent to mention that if it is a case of the complainant respondent number 2, that the offense of criminal breach of trust as 406 and 420 cannot go hand in hand, my lord. And case of the complainant that respondent number 2, that the offense of criminal breach of trust as defined under section 405. Now that particular section I read out, my lord, punishable under section 406 IPC is committed by the accused. Then in the same breath, it cannot be said that the accused has also committed the offense of cheating as defined under section 415. Under section 420, penal is 420 IPC. This court in Delhi versus so and so observes that there is a distinction between criminal breach of trust and cheating. For cheating, criminal intention is necessary at the time of making false or misleading representation, that is inception, from the inception. In criminal breach of trust, mere proof of entrustment is sufficient. Thus, in case of criminal breach of trust, the offender is lawfully entrusted with the property and he dishonestly misappropriates the same. Whereas the case of cheating, the offender fraudulently or dishonestly induces a person by deceiving him to deliver a property. In such a situation, both the offenses cannot coexist simultaneously. Consequently, the complaint cannot contain both the offenses that are independent and distinct. The said offenses cannot coexist simultaneously in the same set of facts as they are antithetical to each other. Here, my lord, the sections of law attributed, again going back to the complaint, my lord. With all respect, my lord. Page 26, my lord. 318 is cheating, my lord. Lordship may have found, my lord. Present case, 318 is cheating and 316 is breach of trust. They cannot go hand in hand. Because a civil dispute, given the shape of a criminal case, and these sections were attributed, my lord. This is one, my lord. Secondly, my lord, there is another, my lord. This is a 2025, my lord. September, my lord. Onukul Singh, my lord. I'm sorry, my lord. Onukul Singh.
Yes.
Seven, no. 18 and 19, my lord. Lordship may have found, my lord. Similarly, in Inder Mohan Goswami and another versus state of Uttarakhand and others, it was emphasized that criminal prosecution must not be permitted as an instrument of harassment or here harassment, my lord, private vendetta. In Gangadhar versus so-and-so versus state of Assam case, my lord, this court again reiterated that a criminal complaint in respect of property dispute of civil nature, here case dispute, my lord, filed solely to harass the accused or to exert pressure in civil litigation. This is in place of civil litigation, criminal litigation, my lord, constitute an abuse of process. 19. Most recently in Shailendra Kumar Singh versus so-and-so UP, this court disapproved the practice of using criminal proceeding as a substitute for civil remedies, observing that money recovery cannot be enforced through criminal prosecution where the dispute is essentially civil. And what is their prayer, my lord? Their two addition. Kindly see, my lord. Exactly these things, my lord, to exert pressure. May I, my lord?
Yes.
My lord, lordship, may I kindly have a look at page 15, my lord. We first placed before your lordships that 420 and 406, they cannot go hand in hand, my lord. The sections law attributed that we have placed. My prayer, kindly see, my lord. A, immediate and direct the concerned police station to, but this is good, my lord. Issue immediate order to freeze the beneficiary bank accounts. Is it not civil dispute, my lord? Take expeditious steps for arrest. 4. Identify and attach assets, properties of the accused of equivalent value to ensure recovery of our funds. Is it not civil dispute, my lord? Have I made my question clear, my lord?
Yes.
First, there has to be, it has to be arrived at that how much amount is due and how much amount is paid. And they are silent regarding that 10 lakh rupees 50 they can dispute because no receipt. But that 10 lakh they cannot dispute, my lord. Have I made my position clear? And if they would have come with clean hands, they would have inserted a line, not talking about 50 lakhs in cash, my lord. They should have talked about openly about that 10 lakhs, my lord. It is missing. Thereafter, my lord. And another authority, my lord, just for, my lord, with all respect, my lord. Here, my lord, the exactly Apex Court granted bail in such a situation where money was due and there is a dispute regarding how much was due and whatever was due, my lord. This is, my lord, Joy Sri versus State of Rajasthan, my lord. This is 2024, my lord. I am reading para 4, my lord, practic, my lord. With all respect and folded hands, my lord. Prima facie, in our opinion, mere breach of contract does not amount to an offence under section 420 or section 406 of the Indian Penal Code. Because here there is a memorandum of understanding MU. If MU conditions are violated, you agitate before a civil forum, my lord. Not lost criminal cases, my lord, because non-payment of dues, my lord. And that too because regarding quality of coal. And it goes on and on, my lord, 4. 5 is, my lord, reiteration, my lord. 5, my lord, with all respect, my lord. In our view, aforesaid position, we feel that appellant so-and-so, their PS bail was granted. 6, in addition, so-and-so, so-and-so, so-and-so shall comply with the, my lord, that is why bail was granted, my lord. This is our case, my lord. It can either be, my lord, in this, today, my lord, with all respect and folded hands, my lord, we have come with clean hands, my lord. Lordship may grant me, I am not saying that grant me absolute bail, my lord. But the period has to be, if possible, my lord, if Lordship is inclined to grant, for a period of 1 month, there will be negotiation. And, my lord, one line may be added, my lord, how much is due and how much expenditure we have incurred, my lord. Have I made my position clear, my lord? Thereafter, if necessary, to pay back, but we cannot pay back if, my lord, we have to pay back during the course of a day, my lord. Then, my lord, when it comes up next time, my lord, that time the period would be fixed, my lord. They within a period of 2 months or 3 months, my lord. Have I made my position clear, my lord? But first of all, the decision has to arrive there between the parties, how much we have paid back and how much was our expenditure. That has to be deducted, with all respect, my lord, from that 250 to 2.5 crore, my lord. Because of this pendency of the this case, my lord, we being coal suppliers, my lord, definitely, my lord, black and white, those things are there. My lord, my other business is also affected. I cannot run my business. I'm losing money, my lord. It is better I pay back, but not the amount they seek by lodging this criminal case, my lord. Whatever amount is exactly due. Have I made my position clear, my lord? This is the tenor I have been told to submit before your lordships, my lord.
Yes.
Another aspect I'm showing, my lord, why it was rejected by the session court. Kindly see that, my lord, that has come to my mind, my lord. It is apparent, my lord, it is a civil dispute. Nothing was done by police. We moved the Court of Sessions. Court of Sessions rejected it. One line is good enough, my lord. Page 28. Rejection order. Lordship may have page 28, my lord. Second paragraph, last 3 lines, my lord. The investigation is still in progress and the role of the petitioner is yet to be thoroughly examined. Hence rejected, my lord. Meaning thereby, there could have been criminality, there could not have been criminality, my lord. This line is very pertinent, my lord. Observation by the learned, my lord, with all respect, my lord, learned the sessions judge, my lord. The pre-arrest bail application, while it was rejected, my lord.
Now it is before us, with the CD is before us.
My lord,
everything is before us.
my lord.
Yes.
My lord, from the bare period of the FIR, my lord, this is a prima facie case of sitting, my lord. Now, I'll take your lordship, my lord. Kindly come to page number 14, my lord.
1-4.
Of the FIR, my lord. Page number 14, my lord. But acting in good faith and upholding almost belief towards Mr. Abhijit Adhikari, as an employee and solely in his assurance to be true, our company Messrs. Ovina Coal, so-and-so, transferred the entire amount to 50 lakhs through account number so-and-so of State Bank of India to Messrs. Himalaya Supply, a proprietorship firm registered under Assam for parceling and selling coal from the land Sonpura, Borgaon district, Soraido, Assam. Now, my lord, how it was paid, my lord, that has been mentioned, my lord, in the month of April, then May, then again in the month of May, my lord. Then, my lord, next paragraph, my lord. The transaction has been made from Messrs. Ovina Cole, having bank account number so and so. The UTR transaction reference under Messrs. Himalaya Supply is referred above in the table. Immediately upon confirmation of the transaction, my lord, this is important, my lord. The said Mr. Dipen Setiapukon has become completely untraceable. All his known mobile numbers are switched off. This abrupt disappearance moments after receiving a colossal sum of money conclusively establishes his mens rea and proves that his inducement was dishonest from the very inception. Now, my lord, next paragraph, my lord. It is further submitted that Mr. Dipen Setiapukon secured a reliance upon a commercial undertaking whereby he obligated himself to secure coal at a specified rate and to vend the same at a lucrative margin, guaranteeing the disbursement of profit our client. Subsequent to the receipt of a substantial upfront capital infusion of rupees 2.5 crores for purchasing and selling coal from the land Sonpura, Borgaon district, Soraido, Assam from us. In the light of this misrepresentation, our client, my lord, this is also very much important, my lord. Our client commissioned a formal site investigation. The investigation conclusively determined that the reference mining area is devoid of any coal reserves and no extraction, transportation or related commercial activity is being or has been conducted. The location was ascertained to be a non-operational tract of land, thereby irrefutably establishing that Mr. Dipen Setiapukon's promises were fraudulent from their inception and made with the intention to deceive and unjustify enrich himself through our client's expenses. Now, my lord, our client, my lord, we have paid, my lord, the informant, my lord, they have paid 2.5 crore, my lord. He is supposed to, my lord, deliver the coal or to transport the coal, my lord. This agreement was valid for 6 months, my lord. Now, this FIR, when this FIR was lost, my lord, this FIR was lost in the month of September, my lord. Agreement was, memorandum of understanding was executed in the month of April, 22nd of April, 2024.
Before,
Sorry, 2025, my lord.
after.
No, after 2025, my lord. 22/4/2025.
Valid up to 22/10/20.
Yes.
For 6 months.
And within the 6 months, my lord, they are supposed to deliver, my lord. Now, my lord, from the bare appraisal of the case diary, my lord, there is no many material, my lord, that he has, my lord, returned 60 lakhs rupees as my learned senior friend has submitted, my lord. There are only the statement of the witnesses, my lord, who has stated, my lord, that we have paid our money, my lord, but the person has not paid any coal or not supplied any, my lord, single coal, my lord, to the my lord, equipment company, my lord. Now, my lord, let the case diary be updated regarding the payment of money, my lord, whether he has said, my lord, the 60 lakhs rupees has been paid or not, my lord. Because the materials have been collected, my lord, it is not shows, my lord, that he has paid a single starting, my lord. Secondly, my lord, 35(3) notice was issued to him, my lord, for his cooperation, my lord. Pursuant to the 35(3) notice, my lord, he has not appeared before the IO, my lord, and not shown any interest, my lord, to come to a conclusion, my lord, for amicable settlement, my lord.
May I just say one thing, my lord? What is the memorandum of understanding, my lord? I don't own a coal ore, my lord. Coal ore cannot be owned by anybody, my lord. Either Coal India or, my lord, nefarious coal activities, my lord. Have I made my position clear? What is there in the memorandum of understanding during its existence, my lord? Lordship, may kindly have a look at page 31. 31, my lord. If supply kotha to kot lekha ase. Oh, Lordship may have found, my lord, page 31. Let us go by the MOU. Whatever they write in good English, won't carry, my lord. The tenor is here, my lord. Page 31, my lord. Purpose. The purpose of the MOU is to establish terms and conditions under which so and so ton of cooking coal supply to so and so supply. Non-cooking coal to supply to MSRDC. Have I made my position clear, my lord? I cannot own a ore, my lord. And now they are saying in the FIR, my lord, in light of their, my lord, Page 14, first paragraph, my friend has read out. Prosecution friend, my lord. It is further submitted that Jitian took, no, good. In the light of this misrepresentation, our client commissioned a formal site investigation. The investigation conclusively determined that the reference of mining area is devoid of any coal reserve. It has got nothing to do with coal reserve. Supply of coal, my lord, it is from the ore, it is carried out to a site, vacant site, my lord, where it is stored. And those photographs we have annexed in your geotag, my lord. And that is not the dispute, my lord. When the period was over, they should have lost this then. So to rectify it, they have stated that my mobile phones were sealed, my lord, closed, my lord. It was not found. That doesn't constitute commission of an offense, my lord. Whether this is regarding commercial activity and non-payment of dues, my lord. We are agreeable to pay back the dues. But whatever we have spent, we have to deduct it, my lord, inclusive of our 60 lakh, my lord. And they have lost the affair after 1 hour, my lord. 1 year, my lord. After expiry. And we paid 10 lakhs, my lord. They have not stated here, my lord. They have not come with clean hands, my lord. That may be on record, verified by police, my lord.
If prosecution wants to verify whether that.
Yes, I mean, as if my senior friend argued, as if it is a criminal petition, my lord. It's a bail application, my lord. But he argued as if it is a criminal petition. He challenged it, says sections, my lord. And he contradicted his own stand, my lord. If he keeps the coal, my lord, in the place, my lord, why he has returned the money, my lord? We have clearly said, my lord, we have visited the site, but there is no coal, my lord. First inducement from his side, my lord. He induces us, my lord, to invest so much of money, my lord. And now he retracted from his promises, my lord. If he so genuine, my lord, whether he intimated us, my lord, that coal has been kept in the places, my lord. Only in the bail application, they have annexed this, my lord. And
Now, what do you say about this?
that I don't know, my lord.
Then get instructions on this, whether he has paid the amount.
Regarding the payment, my lord, if he has payment directly to the informant, my lord, then my lord, none friend will appear. So obtain instruction, my lord.
Let him
Regarding,
obtain
my lord,
instructions.
regarding other part, my lord, from the police station, this is my lord, I'll take instruction, my lord.
But because this is through bank.
Ah, my lord. Police can
My lord, it has to
ascertain.
be,
my
my
lord.
lord, it has to be deposited in cash to
পুলিচক এছাৰ কৰিব বুলি নকওঁ কিয়? No, my lord, the police will verify, my lord, whether we have paid or not, my lord. How can this gentleman verify, my lord? That's a subsidiary, we say, my lord. They let them say that is not a subsidiary, my lord. We are fools to pay to some non-entity, my lord, 10 lakh rupees out of the blue.
But that is only after maybe, my lord, after filing of the
No,
FIR, my lord.
not the filing of the FIR. That is the biggest part of it, my lord. This is prior to the filing of the FIR.
Why
22/4/24.
Exactly, my lord. Prior to the FIR. What is the date of the FIR, my lord? That, my lord, clears my case, my lord. কিমান তাৰিখে FIR হৈছে? 4/9, my lord. Date of FIR is 4/9.
They verified this.
My lord.
You have a copy.
I'll give mine. I'll give. What to copy it?
Heard learned counsel for the petitioner at length. Heard learned additional PP and learned counsel appearing for the private respondent. Course of his submissions, learned counsel for the petitioner has furnished a document indicating payment of a certain amount by the petitioner to the informant prior to the lodging of the FIR. And LPP seeks to verify the same from the IO. Accordingly, is the matter again on. In the meantime, prosecution shall obtain updated CD with the relevant information.
And maybe, my lord, otherwise, my lord, I'll negotiate also, my lord.
The other part also, the remaining part,
Yes.
even if you have given in cash,
My lord.
you must have retained some proof.
Yes, obviously, my lord.
No, regarding 50 lakhs, no proof, my lord.
No proof.
Then, my lord,
Absolutely good
It's a huge
relationship,
amount, my lord.
People like, my lord, lawyers, they have,
No,
not him, my
no.
lord. Definitely, my lord, the
That
drafting
transfer cannot be
itself shows.
placed as per income tax. Act also, my lord.
My lord, meanwhile, if your lordships, if there are materials in the case that this is fraudulently we have placed, my lord. Lordship would reject it, I'll go to jail, my lord. I'm a businessman, my lord, doing business. If local here, they are coming from outside. Some advice, my lord, money would be extracted.
That's why, my lord, we have been.
So, my lord, kindly protect till that date, my lord. Let me negotiate also, my lord, how much I am to pay. And I'm ready to pay. That may be added also. But after negotiation, my lord, it will help their case, my lord. With all respect, my lord. I'm moving around, my lord, with my family. The police is with them because the reason, my lord, the thinking rich, my
Conduct
lord.
of the, my lord, the petitioner, my lord.
Yes, yes, conduct is bad, my lord.
Yes.
But let it be
Then, my lord-
made good by payment
No,
of money,
no.
my lord. Kindly, my lord. Otherwise, it will be
Objection, my lord.
absolutely redundant, my lord. With all respect and full redundant. Only interim, my lord. And if there are materials, also would reject it. Let me appear in court. If this document is not denied. With all respect, my lord.
Yeah, we are adjourning this only for the limited purpose of obtaining that instruction.
Yes, my lord.
My lord.
Yes,
Can
so-
I, my lord? Otherwise, my lord, let me talk. Meanwhile, that line may be added also. How much I am to pay? I'm ready to
That
pay.
cannot be, my lord.
He is not having instruction. I'll
But
pay
I
back
have-
the amount. That is for his own good. And they have, payer is this, my lord. They have lost this case to extract the money from me. It is in their payer portion, my lord. We are agreeable to that, my lord. He cannot say something
kindly see his-
beyond their pleadings, my lord. May I read this line, my lord, of the affair with all respect and full
Kindly
hands,
see
my
his
lord?
conduct, my lord. If he
Full-
gets any.
Don't argue in
any-
between, please.
Not in between.
Full over there. May I read page 15, my lord? Kindly see. Identify and attach assets, properties of the accused of equivalent value to ensure recovery of funds. We are saying we are paying. And he is saying that we need not pay. Can it happen, my lord?
Yes, you also get your proper instructions.
Exactly, my lord. Till that date, my lord, any date. Let me talk to them.
My lord, I am
Regarding
submitting
payment
only.
of- Regarding payment of money, my lord, he is the best person
Yes,
to
my
obtain instruction, my lord. Because we are only the investigating authority, my lord.
হ'ব যাৰ পৰা খবৰটো লৈ ল'বি তাৰ পইচা দিছোতো আমি
Investigating authority can also question them.
Yes, my lord.
Provided
My lord,
he has to
kindly
cooperate,
protect-
my lord. Provided he has to cooperate, my lord.
Yes, my lord.
who will cooperate
He is
every
so
day
genuine,
now my
He
lord
has to cooperate the investigation, my lord.
My
He
lord,
would have,
when,
my lord.
my lord, when
Cooperate the
35,
investigation.
35 notice is served, my lord, the person does not appear. When it is not served.
No,
it
right now
violates
he is
21
saying that I have paid.
exact that is to be
Now,
verified
now both of you can obtain that instruction.
Yes, yes, my
IO
lord.
can also ask him
My
whether
lord,
actually
listen,
any
I
payment has been
I will
paid.
take the instruction, my lord.
One
Fair enough.
person, my lord, he can obtain.
That will-
one
tomorrow
instruction,
morning.
Because he is appearing for the informant, my lord.
Okay, you leave it to the IO what instruction he can obtain. You obtain your instruction.
Yes, obviously, my lord.
And
I will take-
whether-
I will take
whether-
the instruction, my lord.
Whether he is agreeable
Yes, my lord.
to receiving the remaining
Yes, my
amount. Yes.
my lord kindly protect me I'll pay back that may be added my lord upon instruction I am
But-
sending mobile
But
message
if you get any relief,
I'll
my lord,
pay back.
he'll clear away, my lord.
Hey, my lord, let my lord, I'll deposit a bond, my lord, if necessary. I'm a local man where I'll fly away, my lord. Flight this is absolutely missing. He is talking without instruction. Their prayer is to recovery of money. I'm saying I'll pay back. Let me negotiate and pay back the exact amount. They cannot say that they'll.
Further on the submission of learned counsel for the petitioner that the petitioner is agreeable to pay back the
Not the entire amount after
pay back
negotiation. my
the
lord.
amount that may be arrived at
due
after
from me.
negotiations. It is provided that till the next date, in the event of his arrest, the petitioner shall be released on bail of rupees 1 lakh with 2 securities for like amount to the satisfaction of the arresting authority in connection with the aforesaid case. When do you want?
অলপ দীঘল কৰি লোৱা।
Let me on my lord, 19, my lord, or 18th of December, my lord. 19th of December. my lord.
19 লাখি নেকি?
My lord, regarding interim, my lord, my objection may be recorded, my lord.
লাইনটা ভৰাই দিব লাইন
Highly obliged, madam.
Happily, Lordship.
জনহাত
My lord, this criminal revision petition prefer against Lordship mutual final order dated 30/5/2025 passed in FC criminal number 509/2022 by the learned Principal Judge Family Court Borbeta, and for seeking modification and alteration of this order. And I am, my lord, husband, my lord. This was passed under section 125 CLBC. Now, my lord, the first party, my lord, the wife, my lord, after a long spell of peaceful conjugal life, separated from the husband without any reasonable reason, my lord. There is no justifiable reason. And she is a earning lady, highly qualified, and that has also, my lord, has not disclosed in the affidavit supported in this complaint. Now, my lord, I am coming to this. After 13 years, long spell of conjugal peaceful life, and she had left on 13/4/2022 and got married on 19/7/2009. That is, in complaint, it is clearly revealed. Page, my lord, 18. Page 18 is the complaint petition, they filed under section 125 CRPC. And that is, first part is stated that I beg to state that on 19/9/2009, she got married. Now, relevant portion, my lord, when she had left, page 19, finally on 23/3/2022, she stated had left. But the evidence of DW, my lord, DW1 stated, and it is admitted fact
Where
that
is the respondent?
respondent,
No name is shown.
but affidavit objection filed by one, my lord.
But
legal
respondent
aid
column, it is only PP Assam.
Yes, legal aid counsel filed. His name has not shown. His name is, my lord, affidavit reflect one Rafiqul Islam.
Where is the, there is,
He is representing on behalf of respondent number one legal aid counsel.
where is the order appointing anybody as legal aid counsel?
No, but how he filed, I don't know. There is no order passed by.
There was service on respondent number 1 was awaited. And on the next order says affidavit in opposition is filed by legal aid counsel.
Yes, Lord.
Then how come without being appointed?
Yes, the court, the honorable court has yet not appointed any legal aid counsel. So voluntarily, how he can file, my lord, without court permission?
Where is the affidavit?
And here it is also saying that something different view. In complaint petition, my lord, the petitioner, respondent number 1 saying that she had left on 23/3/2022, but in affidavit it appeared that on 13/4/2020 she had left. So two things cannot exist at a time. And so far, my lord, she is earning lady, and that is page, my lord, 36. Page 36. This is the evidence of PW1.
We are not going there now before solving this issue.
Yes, Lord. But by humble submission, my lord, as she is a earning lady and had left voluntarily. So, my lord, still maybe.
Perusal of the order sheet reveals that service on respondent number 1 is being awaited, but it appears that an affidavit in opposition has been filed by legal aid counsel on behalf of the respondent number 1. There is no order appointing a legal aid counsel to represent the respondent number 1. The name of the legal aid counsel is also not shown in the respondent column of the cause list. Not known in what capacity the legal aid counsel has submitted the affidavit in opposition. Hence, list the matter again on Monday. Okay. Showing the name of Mr.
Rafiqul Islam, R.
Saiful Islam, advocate. The respondent column.
Rashid. On Monday.
On the interim is there, they have appeared. Now I have been told that start sheet 5, no? Already appeared statement also recorded, but they are cooperating, my lord. So that may be made absolute, my lord. Nothing advisory in them. Purely civil suit, my lord.
Where is the FIR?
Yes. Fire is also on page 18. 1.
Other of the petition.
Attempt to murder.
My lord, your lord, kindly see page 24. Matter is coming since 1981, my lord. Civil suit, your lordship, order of the magistrate, page 24. Father of the petitioner 2 is the first party, my lord.
You may have a civil dispute, but
All this coming, my so that's why, my lord, your lordship.
Into criminal.
Yes, my lord. So your lordship may make the absolute, my lord, and that whatever law is there, my lord, they will appear as and when required, my lord. Now
in
it
the
is not
TCR
been-
we cannot call for the scan copy. You want to appear, you can appear, but we can extend this only till your date of appearance. Otherwise, if we have to
Only,
decide
my lord,
finally, we have to call for the.
Whom, my lord, he has not been committed, my lord. 109 is a session.
When they will.
Yes.
For receiving someone only they will.
What do you want to do?
My lord, case is not committed, my lord. If your lordship, suppose your lordship direct to appear before whom, my lord? Because not yet committed, my lord. Sessions triable. So once notice appears, my lord, summons issues, then in that case I may appear also, my lord.
Interim maybe.
Yeah.
In their appearance.
It's submitted showing them as absconders.
No, no, I mean, in time, my we appeared, man. Not absconder.
On interim, my lord.
And they appeared before IO. Okay.
Yes,
So they will not be called by the magistrate anymore.
That
They
is-
appeared before the IO.
yes, not required, man.
They will not be shown as absconders since they appeared before the IO. Case will be committed, then on receipt of summons, they will go.
Exactly. Not yet committed, man.
And they appeared when later on.
Yes,
No, no,
no,
we have appeared on 26,
20, man, your lordship,
26/9.
26/9 we appeared, man.
Before charge sheet.
Folks also. That's why not absconder, man.
29. Bail.
It was granted, madam, on
29.
22/9/25.
We have 26.
And we appeared on 26, madam, on oath we are saying, man. Your lordship may record it also.
So we'll say upon committal after receipt of summons, they will appear and apply for bail, then we'll consider. Third, Mr. H.R. Chaudhary, learned counsel for the petitioner, learned additional PP submits that charge sheet has already been submitted in the case. Why? Prior to that, the pursuant to interim protection granted by this court, the petitioner. One petitioner, petitioners have appeared before the IO and their statements have also been recorded. Therefore, the charge sheet was filed. When the charge sheet was filed, they were not shown as absconders. On the prayer of learned senior counsel for the petitioner, this application is disposed of with the direction that upon committal of the case, as and when summons is received by the petitioners, they shall appear before the learned court. Date fixed. And in case a bail application is made, the same shall be considered as per law. Full stop until such date, the order of interim bail, pre-arrest bail dated 22/9/25 shall remain in force. Petition stands disposed of accordingly.
Obliged.
Item 43 and 47, your lord. My submission is on the part that they have on good faith enrolled themselves in the university, your lordship, and the certificates that was being issued was
Item 43 and
43, 47, and 33. I'm submitting for 33 and 43 now. Here are the candidates. And they have enrolled themselves on good faith in the Technical University, and 2 years of they have completed therein. And later on, they have received the certificate, B.Ed degree certificate through a government portal that is.
as per that
Local app.
report, these petitioners are also included. Of that report.
Now my humble submission.
43. So you never enrolled there.
I have enrolled, your lordship. The thing is that. in the-
University says you never enrolled.
Now, lordship, in the website, if the UTID number is being inserted now even, then my name will be displayed there in the university. This is a completely baseless allegation.
It's not a baseless allegation, it's the response of the university.
No, university has to respond to this fact that they have sent my admit card, my B.Ed degree certificate through the government portal. I have received it through the government portal. That is, I have annexed here in your lordship at page 32, 31, 32, 33, and 34. These are the certificates that I have received through the government portal, and this proves that it's an authentic certificate. And moreover, your lordship, the UTI number that is entered therein, if somebody enters in the website now also, my name will appear therein.
Yes, PP, what is this about?
Not 50, 47. 40, 47. 30. 47 has been alleged that he has been therein is a link man.
He's talking about 33.
33 my lord, I have
Saying that he was never a student. Then what is that about the submission of learned counsel, that his name still appears?
I have annexed the certificate.
furnished by the university, my lord.
Lordship may go through the page 31, 32,
All the
33,
students,
34.
my lord, they are never a student of that university. Security of the certificate and the market by the first certificate of digital. Some forgery, my lord. We have come.
Now the UITI number your lordship will see at page 31, 32, 33, 34. This is the number that has been issued, and in the website when therein, if they enter, the name of the candidate will appear therein, that they have taken B.Ed course. And also lordship will see the at the below, there is a DigiLocker app verified signature therein, from which it has been downloaded.
All right.
Go through this content. And for 33 and 43, my submission is same, your lords. And for the 47, he has been suspected to be a link man and nothing else, your lords.
All right.
47, your lordship, he is just suspected to be a link man. He has cooperated with the investigation, your lordship. That's all.
May it please for your lordship. Lordship, on earlier occasion in this matter, the trial court record has been called for you, no? But the record has not been received as per the office note. Lordship may call for the TCR, lordship.
CRS called for has not been, TCRS called for has not been received. Again, on. Registry to issue reminder.
And my lord.
Informed by learned additional PP that the previously appointed amicus curiae is no longer in the profession. Hence, so and so is appointed as amicus curiae to represent the respondent. Number 2. Appellant, represent the appellant. Sorry. registry to intimate and do the needful. Is the matter. So after deductions, who is appearing? Oh, 67 C is not there. Let's do one thing. Where is he lost? Let's call for a report from the jail then. Huh?
Person has been released.
That is why if we call for a report from the jail superintendent, he will inform whether he has been released. Instead of all this amicus. Amicus, now we will not appoint an amicus, not necessary. Cut that. Item 67. It is informed that co-accused Samsung Singh Qatar has already been released from jail upon completion of his sentence. And respect of present appellant Bikram Teron, also the sentence is the same, but there is no information as to whether he has been released. Call for a report from the superintendent. Which jail? District Jail Difu, as to whether Bikram Teron has been released. Is the matter again on?
Services completed, my lord. Who appeared, my lord.
So and so learned counsel enters appearance for the respondent to. You have filed any affidavit? So we admit it for hearing. Bill is admitted for hearing in usual course.
May I please, your lordship? Lordship, as per office note, lordship, service report for the respondent number 2 is awaited. But lordship, as per my instruction, lordship, already service has been completed, lord, to the respondent number 2, lordship. Amicus may be appointed, lordship.
As per your information means how?
Lordship, the complainant and the petitioner, they are the neighbor, lordship. They told that a copy from High Court we have received, but we will not go to the court.
Then you affect justice service.
But my submission may be recorded and amicus may be appointed because lordship, it's been already 5 days, lordship. From last 5 days, lordship, its service is awaited, lordship. Petitioner is behind the bar, lordship.
5 days.
Five occasions, lordship. In IA, lordship, it was filed for condonation. That case also, they was not appeared.
This is the difficulty in affecting justice service. Or you can do it through concerned police station. Where is this? Not Lakhimpur. Hmm? Service on respondent number 2 is not yet complete. Prosecution to obtain report from concerned police station. Is the matter again on? Give it.
A short it may be given, Lordship, because just for report whether it is complete or not. And I we will. Already he's behind the bar for 14 months.
Hmm?
Yes, Lordship. So whether it is completed or not, this information only. See. See. If completed, then again MICAS will be appointed. No, Lordship, a short date may be given, Lordship. For report, Lordship.
19.
Please, your Lordship. Lordship, in this case, Lordship, and was a report was sought for from the OC Soigao, Lordship. But my limited prayer, Lordship, in this case, Lordship, the FIR is registered by the IO, Lordship, and is wrongly registered, and section is put, Lordship, POXO. And apparently, Lordship, I have annexed the documents, Lordship, and school certificate board issued, Board of Secondary.
This IA for bail and suspension of sentence, man.
Yes, item number 7. The NCR has not received. The NCR come out, we have to find out of this thing, man.
My lord,
10 years conviction.
my lord, already 11 accused are granted bail, my lord. Only this person is left, my lord. Well, kindly see the order.
How are they granted bail without LCR?
Yes, my lord.
Yes.
Well, kindly see the order, my lord. IA 8725. In this case, the stand of the PC is there. The stand of the prosecution is there. Mr. B. Sharma lauded additional public publication submits that the allegations are grievous in nature. However, he fairly submits that since the coordinate bench of this court has already granted bail to the similarly situated person, he shall leave it to the discretion of this court. Lord, on this basis, the already 11 persons are granted bail, my lord.
In the same case.
Same case, my lord. Out of same judgment, my lord.
NCR will also, man, will pass.
My lord, already I am behind the bar from the last 1 year, man, after passing of the sentence, after judgment, my lord. Other persons are already granted, my lord. But
It is a perusal after perusal of the.
I have already submitted the orders, my lord.
See the order.
Yes, my lord. All similar sections are involved in all the against all the accused petitioner.
Mr. R.J. Borua fairly submits that since the coordinate bench of this court has already granted bail to similarly situated person, he shall leave it to the discretion of the court.
Without, my lord, without filing a
The objection was filed. If despite your objection, bail has been granted to similarly situated persons, then why should we wait for your objection? Huh?
My lord, we have filed our IA in the month of March, my lord. Now,
This also does not indicate whether LCR had come.
yes, my lord. Petitioner is aged about 21 years, my lord. At the time of trial, he was 18 years, my lord. Kindly consider my application, my lord.
IA. But LCR was already called for long back, 28-25 in the main appeal.
Out, my lord, does not take.
Huh? Where is the judgment?
Then, my lord, Hilali Mori.
Hmm?
Oh, Hilali Mori, Hilali PL. They just attack the doctors, my lord. Doctor and nurse always assaulted with.
From page number 99, my lord. Husband is there, my lord. IA, my lord. Page number 110, my name is there, my lord. In 116, and sentence is just 320, 236, my lord. Number.
Your name is?
Mofizur Rahman. Mofizur Rahman and this. Mention in the judgment that I am a student, my lord. Surprisingly, my lord, only one witness stated about my team. Based on only statement of only one witness, I was granted the maximum punishment.
2025 in respect of applicant Wongfu. I appeared my lord and I have my lord. That is calm with the room.
All right.
Similar nature, my lord. All are similar nature, Baba. Same section, same punishment is given, my lord. 11 persons granted bail, my lord, only my case is. After filing their objection, honorable court granted bail, my lord. My case is not exceptional, my lord. Same, similar in nature. All the prime accused are granted bail, my lord.
Your name is again?
C. Chakraborty, my lord.
No, no.
Mofizur Rahman, my lord.
Mofizur. Mofizur.
Page number 238, CL number 12, at last paragraph.
No, it appears from the judgment that all are on the same footing.
Same footing, my lord.
Same conviction, same footing. All their names are given serially. They committed the following offences, and so there is no need for the LCR now. It is all reflected in the judgment itself. Evidence.
Hey, it is not necessary to file written objection, my lord. They have to also file, they have submitted verbal objection, my lord.
File a written objection, my lord.
In the other cases, they have only one case, they have filed objection, my lord. Other cases, they have not verbally submitted, my
Other
lord.
cases, my lord, I do not know the case. Where I have-
Why you do not know, my lord? My
Where
lord,
the cases where I have appeared, I have filed.
the submission of prosecution is there, why others you do not know, my lord? What is this, my lord? The similar nature, my lord. The very first day they give granted,
No,
my lord.
no. Where is the provision that you have to file written objection? Huh? All right, we'll say that the prayer of prosecution to file written objection is denied.
My lord.
Because after reading all this, I'll have to read all this again once. After spending so much time on the case, again we have to read it. Your copy of objection must be there in the other case.
I have my.
Yes, earlier also you
Last
appeared.
occasion also, my lord.
Earlier that I read out, that is, you appeared in respect of other accused. IA 417 of 25, that is Mokbul Ahmed. This is where you appear.
I have filed an objection, my.
Yes. So that objection will cover everybody because all stand on the same footing. And after considering that objection, court has granted bail. To have even a glimpse at the judgment, it is all on the same footing. All the petitioners are named against the same offense.
In writing again. Opportunity was already given, my lord. They have not filed, man.
Now, has it come up for the first time today?
No, my lord. This is the third time. Okay, LCR is not shown in the.
Already then next week. You were granted two opportunities.
Interestingly, my lord, last occasion, the informant side also appeared, my lord. They said they submitted before the honorable court, they have no objection. The informant is the who filed the FIR, he has no objection, my lord.
On 20/08/25, opposite parties are to file their objection on or before the returnable date. Then next date, 19/11/25, on prayer of learned additional public prosecutor, 1 week's time is granted to file objection. At that time, there was no mention of LCR or received or not received. Then when that 1 week has expired, now you say LCR.
What is his difficulty, my lord? I don't know, my lord.
All right, we'll pass orders.
I don't.
Yes, yes. No objection.
Please, Your Lordship. In office note dated 26/11/2025, there is the service report from respondent number 2 and 3 return back with their signatures.
Hmm?
With return back with their signatures. Office note dated 26/11/20. Service complete.
Mr. Spencer appears for both 2 and 3. It is for 2 and 3. What is the matter for? About?
Allegation is that
IA is what? For what? No, this is not an IA.
I is not mine.
Criminal petition. Okay, list the matter for admission on so and so. Give the date.
Last minute.
Please, your lordship. My lord, convicted under section 10 of POCSO Act for 5 years, my lord. And he is already behind the bar for more than 10 months.